A defect was pointed out by the office that the index and as well as the copy which is to be recalled has not been annexed.
Mr. Rath,
I filed that.
Mr. Rath,
My lord.
as I recollect, sitting with other way,
Yes, my lord.
we have asked you to make payment.
That is,
Then only that is the condition
yes,
precedent
that has
for
already-
consideration of.
I'm obliged by that has already been complied with.
Complied with. And virtually the appeal become infructuous.
No,
Yes.
That's fine, my lord.
With the consent of this WA number so and so is for default for non-compliance of
yes, my compliance of payment of dues that has been done.
for non-compliance of certain orders. Run counsel for the equivalent states that the said amount has been most of with the consent of the parties. This application is allowed. The order dated so and so stands.
It is to be taken for admission some of the day, my lord.
No. First of all, we are here just to
Restoration of the writ appeal.
stands restored to its let's WA number so and so be restored to its original file. Yes.
After my case will be tagged up this. So it has not been listed. May I pray that my case be taken up?
Grateful.
Maybe title to make it. Disposed of petition disposed of by my lord Justice, Honorable Dr. Justice Sarangi and Justice Sapwar. I have filed an IF for extension of time to comply the order. That area is to be listed by constituting the.
Why? You can just give this slip
Yes.
before the Deputy Registrar Judicial. He will place the file before me. You are not required to make a mention. Such slips should be given to him, he will place it before.
I beg your pardon, my lord. My lordships have get two matters on 18/7 for final hearing, my lord. One virus matter and one writ appeal. My lord, lordships, some of the writ appeal has not been listed, for which we would not argue, my lord. My lord, your lordships have kept two matters, my lord. One is writ appeal and one is virus matter together for hearing, my lord. Challenging the Odisha Elementary Service Commission, my lord. Lordship, some of the writ appeal has not been listed. So I, sir, lordship, pray that this matter may be tagged out will be. 18/7.
To be listed. Give.
May I please your
Why
lordship?
haven't some of your matters been
No,
listed?
my lord. Not a single matter has been listed
But
about
you can
that,
argue.
for which you could not argue, my lord.
I may be permitted to mention your lordship.
May I?
WPC 14151 of 2024. This is a matter where we are challenging the virus of Rule 83A of Central Excise Rule 2002, your lordship. This matters were earlier listed because the division bench of Honorable Justice B.R. Sarding and Honorable Justice G. Satpathy, your lordship. The bench directed that the matter be listed before the appropriate bench as it is containing the challenging of the virus of the rule. Lordship, we are led by Mr. Tarun Gulati. He's from Delhi, senior advocate. He has proposed a date 18/7 to be listed, your lords. I request your lordship.
That is binding on us.
No, your lordship. This is not binding.
Not
Your
the
lordship.
way to make
He has requested us, your lordship. That is, I am just
Not
making a
the way.
request.
We'll see.
I may pardon your lordship. Single
We'll
bench
see.
contempt matter of your lordship.
Right.
Your lordship, single bench contempt matter of your lordship. Single bench contempt matter of your lordship.
All right.
It has been taken
All the
over
cases
5
have been-
times, but the opposite party had taken time, your lordship.
All right. This is of which year?
2023,
So we are taking up 2017, 2016, 2015 matters.
lordship.
Please wait.
My lord, in this case, my lord, the petition challenging the attachment going to be attached the account of the present petitioner, my lord, during pendency of the section 37 of arbitration caution act is pending before the honorable district judge, learned district judge Contempt, my lord. This is my lord assigned to court number 16. Mr. Dipin, the senior advocate, is concerned that court, my lord. The matter may be listed any other court, may be directed, may kindly listed any other court.
You can change the counsel.
He is the arguing counsel, my lord, in this case, my lord.
You may be arguing or you can change the counsel. Is he the only senior counsel in Odisha?
No, my lord, the petitioner is engaged Mr. Nanda, is senior advocate to.
Never do this. This is this amount. This is called bench hunting, you know.
No, no, my lord.
Sorry. You want to change the bench, not the lawyer.
Yes, my lord.
You would-
But this is concern bench, that's why.
You have understood, you have understood.
I will,
Yes. Sorry.
I will, pardon to make mention, my lord. Item number 33, my lord. That matter relates to installation of fire safety system. Yesterday I have mentioned, my lord. May I only pray that the matter may be taken up today in course of the day.
Well, we will try.
If it is not.
We will try to be faster.
We have filed the affidavit,
Yes.
and we have sought a copy to him.
We'll give a reply.
All
in
right.
course of the day. Obliged.
Your lordship has directed to the opposite party to sometimes the retirement benefit to the petitioner in the review number 21, 2019.
So what do you want?
Any of the contempt number 5185.
What do you want, madam?
Opposite party not carry out the
This
land.
is a
acquisition
contempt
order.
matter. Huh?
Opposite party
Contempt matter.
contempt matter.
Wait for some time. This is of which year?
2023.
Wait for some time because we are taking up 2017, 2016 matters. Please wait for some time. Make a mention after 3 weeks. All right.
Pardon to mention, my lord. item 58, my lord, on behalf of Mrs. Jana, she is out of station. Kindly be taken up next week, my lord.
All right. 58.
Pardon to make mention, my lord.
Have you informed the other side?
And that is the content matter, government is. Pardon to
Contempt matters also there are.
Pardon to mention, my lord, my sincere apology. I yesterday mentioned the matter, item 52, kindly be taken up as a last item if it could not reach.
We will take up.
My,
My lord, for minimum mention, my lord. There was a case filed as LPA, but the SR has objected and they have mentioned that it should be written up. So I have filed an IA for this for the modification.
No, no, that can be done in the office. Why have you come here?
My lord, they have objected and they have.
No, but why did you file LPA?
My lord, that was against a single bench, which has been the order of the single bench has been challenged, but the SR has given this objection, my lord.
So is that objection wrong?
My lord, that's the point I was about to tell, but they have asked to file an IA for the modification of the nomenclature.
You mean to say LPA is the correct nomenclature?
I feel, my lord, that, but
Have you
the
not
SR
gone through
has.
the High Court rules, the nomenclature, different nomenclatures that has changed since a few years?
My lord, may this be allowed, my lord.
No, but such things should be defects should be removed at the level of registry. Give your slip, you'll see.
My lord, thank you, my lord.
Lord, I pardon, my lord. 1 week before this matter was in the list, it has been delisted, my lord. I just want to press the amendment petition, but unfortunately, before 1 week before, it was in the list.
What
but
is the urgency?
urgency is not unless there's an amendment petition allotment, it was in the hearing list. I mean, for admission.
What is the amendment?
Amendment is that some new documents which I got letter, I want to introduce that, my lord, and just want to modify the prayer only.
In the appeal?
No, in the writ petition, my lord.
In the writ petition?
Yes, my lord.
We will see. We will see.
Can it be taken up
Slip.
on Thursday or Friday in the
Slip.
I may pardon to make mention. Yesterday, your lordship has asked me a question that Universities Act,
Yes, yes.
that Universities Act 2020, section 21(4), it provides, I can give a copy that is not with me. May I read, my lord, that section?
Yes.
The register of the concerned university shall ordinarily by the last date of December of every year make a requisition to the commission subject-wise vacancies of teachers, including anticipated vacancies of the next calendar year, indicating number of posts reserved for different category, can in accordance with the provisions of relevant acts or rules, orders, resolutions, or instruction issued from time to time by the state government.
This is
2020 amended rule amended Act 2020, which was challenged before here. The Lordship has also confirmed that act, but that is under challenge before the
Amendment Act.
2020. ma'am.
So before 2020, this was not there.
This one not there. This 2020 Act is there.
Are you sure?
Yes.
Please examine
Yes, I will examine. Just
that what was the position before
before
that.
2020.
All
Yes.
right.
Fine.
I may be pardon to make a mention, your lordships. Lordship, this matter is relating to the extension notifications pursuant to 168A, lordship. One matter is left. Pursuant to 168A, that extension notification also I have challenged. One matter left. I may be permitted to file the memo so that it will come, and next week, your lordship.
Where is your memo? Give it. Yes.
Submission item number 1.
Item number 1, the order has already been completed.
Just now given the order, my lord, by the special, and that has been rejected the representation, stating that the RSD has been executed in the year 1945. That has no knowledge regarding this, my lord.
You can challenge that order. We give you liberty to challenge the order.
Yes.
London AGA has informed this court that the petitioner's representation has been disposed of in compliance of this court's order dated 5/4/2017, passed in WPC number 4923 of 2017. A copy of which has been supplied to learned counsel for the petitioner. So, the petitioner's representation has been rejected by an order dated
11/7/2024.
11/7/2024. So, in such view of the matter, though we express displeasure over delay in disposal of the representation, we are not inclined to proceed in the present contempt matter in view present contempt matter in the given facts and circumstances of the case. First off, the contempt proceeding is dropped with a liberty to the petitioner to question the correctness of the order passed on the petitioner's representation.
I may be
Yes.
pardoned, but
I mean,
it's 11/6, not 11/7.
that has been the order signed by
11/6.
11/6. That is 11/7.
11?
The order signed by the special LO, that is 11/6, not 11/6, my lord, that is 11/7.
No, it's 11/6 code 7 লেখা আছে।
It is not 11/6.
No, 11/6 ମୁଁ କରିବ ନା। I corrected it 11/6.
But the letter is addressed at 11/7.
Arey সেটা that is addressed to me. I don't understand. It has been addressed to me on 11/7, communicating the order dated 11/6. Where is the difficulty?
All right.
Item number 2.
Your lordship may look at your lordship's last order. A file was called for. WPC number 4189 of 2023.
Yes.
Here, my lord, in the read petition 2280/23, the order of the appellate authority dated in the year 2001 was challenged. Beforehand, this writ application was filed 4189/2023 and was disposed of. Therefore, your lordship considering it necessary and since it was not available with me, your lordship called for that filing yesterday.
You can see the prayer in the last prayer. You made a representation to get refund of the amount, and that is why the honorable court has said your representation will be considered.
Whether this fact you have mentioned in your petition or not, the present writ petition,
No, my lord, it was
what
not.
was your relief?
No.
No.
Then you have misrepresented.
My lord, here, my lord, there the challenge was to take demand notice. And demand was made, OPDR, under OPDR Act also demand was made, and demand was already paid. So that prayer has become infructuous.
Just a minute. This WPC 4189 of 2023. The earlier petition,
Yes.
Mr. Mohanty,
Yes, my lord.
what was his prayer?
To
My lord.
refund, he made a representation that the amount.
Prayer was
Prayer was to, my lord, I
challenging the demand notice.
quash demand notice.
Challenging the demand notice, but the prayer is specific that it may be refunded or adjusted.
No. Prayer is specific that challenging the demand notice.
Demand, pass the demand notice. Yes.
Now, my lord, that was on the OPDR Act, the demand was made also. We have paid it and receipt is annexed. So that prayer has infructuous. Now the question of refund and the
No,
appellate order.
You had prayed, challenge the demand notices.
Yes.
But the writ application was disposed of
On
for disposal of your representations.
my lord.
Yes.
But that is same, sir, same, but in this
Exactly,
petition,
exactly.
that is no certificate that earlier he has moved. to-
That is a mistake done by the.
That is the only thing which I.
But
the fact
Here when
remains,
the matter
Mr.
of office
Counsel,
is-
that
was never before this honorable court.
you did not challenge the order of the appellate order was already there.
Already there, 2021. It was
You
passed
did
in the
not
year.
challenge.
I challenged it in a second appeal. Second appeal was not maintainable. Therefore, that second appeal was not pressed in the year 23. Then immediately I filed this writ application challenging the appellate order.
No.
Your lordship may look at
The appellate
page.
order was. The appellate order was passed in 2021.
In a wrong motion. It was filed in a second appeal. Though second appeal is not maintainable in the eye of law.
Where? In RBC second appeal is maintainable.
No. Second appeal is not, no provision of second appeal so far mining law is concerned. Your lordship may look at that. I have also annexed.
Will you hear us, Mr. Counsel? Do we have any right to be heard?
Yes.
So when you filed your earlier writ petition in 2023, there was an order, appellate order passed in 2021.
Then only demand notice was challenged. Now it has been paid.
Fact of second appeal is also not disclosed in the present writ petition.
My lord, page 20, annexure
Page
6.
20.
My lord. It was wrongly filed before the collector cum appellate authority.
Mr. Whether you were required to disclose all these facts in your present writ
Certainly, my
petition
lord.
or not?
That was drafting counsel. Sir.
Drafting counsel.
My lord. Now fact remains that was paid. So demand notice is not now a question before my lord. Only the appellate order is a question. If your lordship entertained my prayer, then no consideration of that appellate order.
Why did you not challenge that order in the last writ petition which was filed in 2000?
My lord, at that point of time, the second appeal was pending.
Nor have you disclosed that.
At
You are
that point
playing
of
hide and
time,
seek.
the second appeal was pending.
Yes. How much?
Second appeal when filed, when it went, there is no order also.
How much? How much? How
Your
much
lordship may
cost?
look at that was not pressed on.
How much?
Thereafter, immediately the writ application was filed.
Tell us the amount. Tell us the amount.
Amount is, my lord,
Because you have concealed the facts, so many facts in the presented application.
lordship may forgive for the first time, then,
Forgive, no forgive.
my lord, your lordship may
You
forgive.
made us call for the records of the previous case
My lord, I am
to
sorry for,
understand.
I am sorry for that. I
So
should
you
have
are, you should
maintained.
not, you should be happy about it.
No, I am not happy, my lord. I am also sorry for that.
You should feel happy.
Lordship may forgive and consider it on merit, whatever
We
the.
are there, we will consider it on merit. More orders. Yes, we will pass orders tomorrow. We will take into account all the aspects.
Item number 3. Item number 3. Order.
Lordship,
No, no, we will dismiss with cost. There is no question of disposal. See, you made your submissions yesterday. You did not have the writ petition, previous writ petition.
my lord,
We had to call for the writ petition. And after having called for the writ petition, we are in a position to understand what facts were there in the writ petition. Our question was that why are you challenging an order passed in 2021, in 2023? You did not have any answer.
my lord, my second appeal
And
is,
today you are saying that your second appeal. Today you are saying that you did not challenge the order and those facts you did not disclose in the present writ petition. So we must discourage such practice. Yes, next.
my lord,
Item number 3.
another writ petition is there also. my lord.
Where?
In the connector writ has also come.
Where? Which item? Together?
After my representation was rejected, it was challenged.
All. Both the judges.
Sir, item number 3, I filed the compliance affidavit on 12th of this month. We've complied the order.
Who is there for the?
Lordship, in fact, I am for the petitioner, Lordship.
The order has
Lordship, sorry, Lordship, I am PC, Lordship.
Yes.
Lordship, now Lordship liberty to challenge that order, but they took 2 years instead of 3 months, Lordship.
My lord, sorry, my lord, to interfere.
All right, just a minute. And he states that the petitioner's representation has been disposed of, and thus this court's order violation of which has been erased in the present contempt application has been complied with. So, when counsel appearing on behalf of the petitioner has submitted that the opposite parties have taken 2 years to dispose of the representation which was to be done within 3 months. First off, next, be that as it may, while expressing our displeasure over delay in disposal of the petitioner's representation within the time stipulated in this court's order, we are not inclined to proceed any further in the present contempt proceeding. Contempt proceeding is accordingly dropped. Yes, next.
Item 4.
My lord, sorry. My lord, cost I shall pay, your lordship direct me, I have to pay.
Why should you pay?
Well, I could not follow your lordship of the cost.
See, you have filed a writ petition. The court has a duty to decide that. The
Right.
court will decide that. The court may allow your writ petition.
My lord,
The court may dismiss your writ petition. The court may, while allowing the writ petition, impose cost on the other side. The court, while dismissing your application, may impose cost on you.
my,
So give that liberty to us. All right. Yes.
I shall pay cost, then my writ application would be hard.
No. That is not the,
That impression therefore I disturbed your.
now we have explained everything.
Item number 4.
Appellant challenges the order passed by the Honorable Single Judge, wherein the Honorable Single Judge at the first instance has allowed the writ application. Let's kindly look at the order portion first. That is at page 41. No notice was issued. Page 41, para 9. May I please, my lord?
Yes, please.
In view of the aforesaid settled position of law, the court deems it proper to dispose of the writ petition at the stage of admission by directing the opposite party bank to consider the case of the petitioner and sorry, my lord, and to grant them wages as directed by the Honorable Supreme Court in Umadevi, as well as the judgment passed in coordinate bench of this court, the Satyanarayana Patnaik case. Accordingly, the opposite parties are directed to consider the case of the petitioner as such the benefit and grant benefit as due and admissible to the petitioner with a period of 2 weeks. So positive direction has been made. My lord, the lordship will see the petitioner claims to be a daily wage employee, but he has not filed any document to the extent that he has been working under the bank. My lord, in writ appeal, you have categorically stated, had he got the opportunity to contest, you would have said that he was not our employee and he has not been engaged by us. That ground I have taken in the writ appeal, my lord. And the thing is that the judgment which my lord is, my lord, the Satyanarayana Patnaik case means the bank had admitted the engagement of the petitioner in that case. So that is the reason why, basing on this and the para 40.
Yes.
My lord, this two things are involved.
No, the only question involved is that the writ petition was disposed of on the same day
Yes.
without giving notice to the bank with a positive direction.
Yes.
Whether this order can be sustained or not. That is the only question.
Yes. This is a question of point of law only. There are two things. One is point of law, another is point of facts.
So even on the point of law, the other side had a right to be heard. That was not done. That will be heard.
My point is, point of law is very clear. The pattern of judgments of Supreme Court as well as single judge as well as division bench tell you as people they have to be paid wages at par with the lowest.
The law depends on facts. So whether all the facts which you had asserted in the writ petition were admitted or not is a question. They could have denied, they could have accepted. Then the question of application of law would have arisen. But here, the very first day. So we will just remand the matter back. We are not taking away your right if you have.
With a liberty to sign supporting documents.
Including liberty to file counter appeal. So all the
exactly the same fact, same period, same order, everything.
Same order.
Same order.
Separate orders will have to be passed in all the cases.
Only the petitioners are different, otherwise everything is same. Governments are also same, writ petition is also same, everything.
But separate orders have been passed.
Separate orders have been passed.
Yes, ma'am.
Because separate writ petitions are there, so separate orders.
The UCO Bank to the zonal manager, UCO Bank, Balasore, has put to challenge an order passed by the learned single judge of this court dated 11/12/2023, passed in WPC number 39674 of 2023. So, the respondent, had sought for a direction to the Zonal Manager, UCO Bank, Balasore Zone Office to enhance the wages at par with initial basic pay with DA paid to regular sub-staff of the bank with effect from 2023 20 and also revise the same as and when the wage revision takes place. Full stop. It was the case of the respondent in the writ proceeding that he was engaged on daily wage basis by the UCO Bank, Ghasipura branch on 31/12/2014 and had been getting a sum of rupees 300 per day. For stop. Challenging the low wages paid to the petitioner, to the respondent, he had approached this court by filing the aforesaid writ petition, that is WPC number 39674 of 2023. Full stop. The writ petition was filed on the writ petition was filed on
For 4/12/2023, as the date is there in the page 16.
4/12.
Page 16, the date they have put it 4/12/2023.
4/12/2020. All the cases are filed on the same day.
Same.
On 4/12/2023. Stop. Learned single judge disposed of the writ petition by the impugned order dated 11/12/2023. On the very first day when it was taken up for admission with following positive direction, paragraphs 8 and 9. Stop. Next, assailing the impugned order passed by the learned single judge, Mr. Mishra, learned senior counsel appearing on behalf of the appellant, has submitted that before passing of the said order, the appellant was not noticed. Stop.
No, my friend had appeared to only to obtain instruction from the bank. He was not allowed to file counter. I mean, my learned friend was there.
Notice
It is covered case, so no need to file counter.
on the same day without
Any notice he had applied. That Without a notice, he had appeared actually, since he is the empaneled advocate of bank. So he had just appeared.
Without any formal notice to the bank, though in the presence of learned counsel who represents the bank. This court. So stop. He has submitted that the respondent was in fact not an employee of the bank, even on daily basis, and had the bank been given an opportunity to file an affidavit, the facts would have been brought to the notice of the learned single judge to make out, in order to make out a case that the decisions relied on by the petitioners, decisions of this court and the Supreme Court relied on by the respondent, they are not applicable in the facts and circumstances of the facts and circumstances relating to claim of the respondent as raised in the writ petition. So stop. Next. Learned counsel appearing on behalf of the respondent has argued that the petitioner's claim was based purely on legal issues and no factual aspect was required to be addressed by the learned single judge. Stop. Therefore, he contains, the nature of decision of order passed by the learned single judge does not suffer from any legal infirmity requiring this court's interference in the present intra-court appeal. So stop. Next. After having perused the impugned order passed by the learned single judge and considered the submissions advanced on behalf of the parties, we find substance in submission made on behalf of the appellate. So stop. It is evident from the impugned order that the learned single judge examined the materials on record as brought on record, materials as brought on record along with the writ petition by the respondent. So stop. Learned single judge thereafter reached a conclusion that the case of the respondent was identical to those who had earlier approached this court, namely Sri Satyanarayan Patnaik, to an employee, namely Narayan Patnaik versus Narayan Patnaik, whose writ petition was disposed of by an order dated 10/11/2014. directing the bank to pay wages to daily wage earners equal to the salary of lowest paid employees of their cadre in the service of the bank. Full stop. Next. Since a specific stand has been taken on behalf of the appellant that the appellant controverting the respondent's case that he was employed by the bank, comma, we are constrained to interfere with the impugned order passed by the learned single judge. Full stop. Next. We are of the considered view that a positive direction dealing with the facts should not be issued without giving an opportunity to the other side to admit or controvert the facts. This is for the reason of facts by filing affidavit. This is for the reason that the writ proceedings are decided on the basis of affidavits and it would be unsafe for the court exercising power of judicial review to decide matters based on the factual aspects as disclosed in the writ petition only. Stop. For the said reason, the impugned order passed by impugned order dated so and so is set aside. Let the matter be placed before, let WPC number so and so set aside, WPC so and so, let WPC so and so be restored to its original file and be placed before the appropriate bench having the roster.
Much obliged.
Yes. Good. Feel is allowed. We make it clear. Senior counsel appearing on behalf of the appellant has undertaken that a counter affidavit shall be filed in the writ petition within 2 weeks.
Maybe 1 more week, 3 weeks.
3 weeks. You had not given any document about your engagement.
We have given a list of the days, but that at that time we have not given.
If such.
We will
counter
be given the
affidavit- if such
opportunity of
counter
giving our agenda.
If such counter affidavit is filed within 3 weeks, upon serving a copy thereof on learned counsel for the petitioner, respondent, comma, the respondent shall be at liberty to file a rejoinder thereto.
And that decision of Satyanarayan Patnaik, which we were relying on, you are the counsel there, their counter had been filed and they had admitted
They
that
have
you had been
admitted,
engaged.
I've
No,
filed
that
that
case, it
judgment.
has gone to
I've
Supreme Court
filed
level.
copy of that judgment.
Yes, yes, that is what I was going
So
to.
that case, it has gone to Supreme Court level also.
Yes.
So their bank has admitted that you are an employee and they had given you fixed wages.
Still,
And here you also there, but
Or
unfortunately,
you will file documents.
yes, we'll file documents.
Much obliged, my lord. But the other cases, my lord, only case numbers and petition number will be different. Much obliged.
Item number 5.
Made, please. I'm challenging the order of the Honorable Single Judge. Here the background, your lordship may kindly see annexure 1, page 17. Government of Odisha had introduced an
so
online.
where is the order?
Lordship, order is at page. Lordship begins at page 34.
34. Yes. So you did not file any counter affidavit.
Lordship, counter affidavit was filed, but I fairly consider it was not elaborate. It was a small counter affidavit, wherein only in brief it was indicated that as because the college did not have funds and it was not possible on the part of the college to continue further, in the changed circumstances, his services were done away with, and a regular junior clerk who was also trained in computer science, that is respondent number 3, he was given the work of data entry operator. Here, your lordship may kindly appreciate that the appointment order is at annexure 4, page 24. Your lordship may kindly see for a moment. The appointment letter says that you are appointed as SAMS DEO. SAMS DEO, your lordship, after introduction of SAMS, that is an online portal for admission into +2 and +3 colleges in Odisha. Initially, your lordship, there were nodal colleges, 113 nodal colleges, where the SAM centers were put up, and the nearby colleges also came to that center for the purpose of admission. Accordingly, there was generation of one requirement of a data entry operator. But with time, your lordship, all the colleges were equipped with computers and data entry operators, so that system of nodal centers was not there. And this SAM's data entry operator, his entire salary was managed from the funds that were generated from SAM's. Your lordship knows that the admission session begins between July to August and ends normally in October and November. Thereafter, regular classes continue and no further admission is there. All cases of transfer, registration and everything are mostly over by the month of November. So accordingly, your lordship, after November, when there was no work available, he was terminated. And thereafter, a junior clerk was also trained in computer science, after taking the approval of the governing body, was appointed. This fact, your lordship, in brief has been brought to record in the counter affidavit, but has not been elaborated. And as your lordship may appreciate, this appointment was purely a personal contract between the college and the respondent number 4. And it could not have been the subject matter of a writ petition. And for that purpose, I rely upon involving this fixed term and personal contracts. This is the guidelines set by the Honorable Supreme Court. Your Lordship may kindly see para 68. The guidelines have been set. May I please?
Yes.
We may sum up our final conclusions as under. An application under Article 226 of the Constitution is maintainable against a person or a body discharging public duties or public functions. The public duty cast may be either statutory or otherwise, and where it is otherwise, the body or person must be shown to owe that duty or obligation to the public involving the public law element. Similarly, for ascertaining the discharge of public function, it must be established that the body or the person was seeking to achieve the same for the collective benefit.
Those are
of
general observations.
general observations. The specific, Your Lordship, may kindly come to D, clause D, Your Lordship. Even if it be
So
perceived,
this is a private school.
this is regarding a private school and this is a private college. Appellant is a private college, aided college.
Yes.
Aided college, my lord, not private. It is aided college, not private college.
Fully aided. Fully aided college.
Yes, fully aided college, my lord, from the government.
But Lordship, this appointment was purely a fixed term appointment made by the principal from out of the funds that were available by.
The only ground on which single judge has passed the order is that you removed someone
Lordship.
and in his place you appointed someone.
No, not in his place, Your Lordship. The appointment is the second appointment, Your Lordship may also kindly see, that is at page 6. He is a junior assistant. This particular respondent number 4, Your Lordship, was appointed as SAM's data entry operator. That is specific for the purpose of SAM's. He had nothing to do with the other college work. But the respondent number 3 was appointed as a junior assistant who, in addition to junior assistant work, is doing data entry jobs. And as on date, Your Lordship, also, he is continuing. He was also a party to the writ petition, and there is no direction with regard to his appointment or engagement continuance. And he has not been noticed, Your Lordship. He has to be noticed in the appeal.
Yes.
He was noticed in the writ petition, never appeared. Appeal number 3, never appeared, despite twice notice was special messenger. And my lord, this notice, the petition, the opposite part, not the writ appellant, that did not appear based on a single judge, time and again, it's kindly see the order.
There was a post,
Ma'am.
according to you,
Yes,
against which you were working. You were removed
my lord.
and respondent number 3 was appointed. Whether his appointment has been cancelled or not.
That my lord, on single judge decided my appointment is illegal, my term is illegal, I died to reinstate in service.
So where?
The
Reinstatement can be where? The
where,
person is already working.
I was posted in +2 wing. I was posted in +2 wing. Respondent 3 in +3 wing. There's 2 separate wings, my lord.
All right. So therefore that ground was not available. According to the learned single judge,
My lord.
you were disengaged
My-
to accommodate someone else.
My lord.
This is the finding.
Yes.
You are saying that no, it is not a fact.
Right.
He was working somewhere else and you are working somewhere else.
My some people on therefore on a single judge, time and director to file affidavit to disclose all the facts. And time and again, they're taken time, kindly see the order and never filed any affidavit.
So,
Yeah. Therefore, on a single judge, relying on the documents placed before him.
then the learned single judge could have set aside the engagement of respondent number 3.
That is my discretion. Our single that
Without setting aside his
That-
appointment, how
that my lord and the And the appellate court decided that unless the judgment of a single judge is barbarous, retrieval should not be entertained. That's condition. And they are given opportunity, sufficient opportunity to file affidavit.
So
They are-
according to you,
My lord,
if the judgment of learned single judge is illegal,
my lord.
the court should not interfere.
No, that is not my submission. My
This is
submission
your
is,
submission.
no. Unless the barbarous, the word is like,
Therefore, Mister,
My
we understand the difference between something which is illegal and which is perverse.
my lord.
So, and perverse has very, very negative connotation.
My lord.
All right.
Yes.
So if an order passed by, this is your submission, that if an order passed by a learned single judge is illegal,
No.
then the division bench should not.
Here,
interfere.
if order illegal, that cannot. But here in this case, they have been
Just
giving.
a minute. If the order passed by the learned single judge is illegal, then the division bench should not
Yes.
interfere.
If order illegal, they can my lord interfere. But here is the case.
All right.
Here in
Which
the
case the court should interfere and which case the court should not interfere.
my lord, that the appellate court decided that unless that giving judgment, my lord, unless the order and only one paragraph,
Yes.
only one paragraph 4, my lord, only
So
nothing else.
you are restraining us from reading.
No,
other
my lord,
paragraph.
only paragraph 4, my lord. Of those,
Yes.
my lord. Only paragraph 4, the operating part only.
Yes.
May I read, my lord? That is only finding. And he has given sufficient opportunity, nor opportunity filed. Reliance upon documents before my single, they have passed the order.
Absolutely. All right. If you want, we also want to deal with this aspect. Because this argument is being made in so many cases that unless the judgment passed by the single judge is perverse, the division bench should not interfere. We will decide this. All right.
That is my and I issued termination without any notice to me. Simply sit down after 6 months, you go.
And is this the only decision on this point?
No,
That unless the judgment is perverse, the division
That-
bench should not.
the reasoning, well, my submission, honorable single given a sufficient opportunity to them to file affidavit. Nobody appear also. Nobody appeared at all.
Issue notice.
That is up to my lord.
You receive notice on behalf of
Opinion number 4.
OP number 4. You for
For 1 and 2.
1 and 2. Step notice. Okay. Respond number 3. The requisites. Respond number 3 is the person who is working.
Working.
Requisites 1 week. 8 weeks. Stop. With further orders, the impugned order passed by the learned single judge shall remain stayed.
Item number 6.
Can I pray, my lord, the number 6 here, Mr. S.S. Rao, senior advocate, has been engaged. I think he had also filed the appearance memo. His name was there. I don't know today why it is not appearing. Can it be passed over or your lordship may?
Why don't you know? You should have inquired whether he is well, he is unwell.
Who?
Mr. Rao.
No, he's here.
All right.
He's here in the
court.
another, he's on his legs in
All right.
another court.
What do you
Maybe
want tomorrow?
tomorrow is holiday, day after tomorrow.
Day after.
My lord, oblige.
I had requested on behalf of the.
He's very much here, but his name may be printed here. Appearance memo.
What is this matter on? Thursday.
Item number 7.
Here, my lord, the order challenged before this honorable court, my lord, is the honorable single bench order in annexure 10, my lord, page 65. It's a disciplinary proceeding matter, my lord. Punishment of 1 black mark was imposed. Thereafter, my lord, the appeal rejection, thereafter, my lord, the writ application and writ application, my lord, my lord has paraphrased, my lord, the entire factual aspects and the submissions made by both the sides. And my lord, come to the conclusion, last page of the brief, my lord. Page 76.
Yes.
But the honorable single judge, my lord,
Yes.
what to talk of, the entire proceeding was started, my lord, on a non-existent allegation. That was not specifically pleaded. If you also look at the honorable single
Just a
bench,
minute. What was the allegation?
allegation, my lord, can you come to page 66? My lord has indicated what were the allegations are. But these are not the allegation, my lord, based on which, my lord, this charge was framed. And I have been taking up this issue, my lord, throughout. My lord, can you see page 66, para Roman I? Petitioner, while was posted to Sea Beach Police Station as IIC, one James Frederick Gorman, a US national, appeared on 26/11/2013 in the Sea Beach Police Station and reported orally that one Matthew Fury, French national, had indulged in sexual abuse with 4 children in the Kajunera jungle at Penticata. While he tried to take photographs of the foreigner, Matthew Fury, the said foreigner assaulted him, causing several severe injury on him. Although the incident was related to involvement of foreign national, IIC did not take any formal inquiry investigation into the incident. This is exactly the allegation. If you also look at the basis, my lord, that your lordship will get at page 20, my lord, annexure 2. My lord, got page 20.
Yes.
My lord, while I was in another investigation, my lord, out of police station,
No,
a man
we
came.
will not go into the facts.
No, I just only indicate this aspect.
Mr. Where is the charge?
Charge, my lord, is annexure. That starts from page annexure 1, page 16. Ma'am. The charge was issued on 13/10/2015.
Just a minute.
Ma'am.
Annexure 1.
Annexure 1, page 16.
Yes. Just a minute.
Ma'am.
So this was the charge.
Yes, ma'am.
An inquiry was conducted.
The inquiry was conducted.
What is the finding?
Finding, my lord, if you also look at the inquiry officer's finding, that is, my lord, the annexure 5, page 30.
Yes.
Analysis of evidence, my lord.
So the findings, the charge against you were proved according to the inquiring authority.
According to inquiry officer, my lord, the allegation which was made, the foundation was 26/11/2013. He has said there was no allegation of this nature, my lord. But he has said he has waited up to 2/12/2013, my lord, to register FIR. If you also look at last 3 lines, my lord, page 36. He has said, though the reporting in station diary in CBH PS on 26/11/2000 by the SD numbers Franco was not revealing a cognizable case, but it could have been inquired thoroughly by the IIC himself or on other senior officer of the police station. He could have intimated the development of 26/11/2000 regarding the foreigner issue.
So the occurrences of 2000 to 26/11/2000.
Yes.
Then
That's why I wanted to Lord Simala to kindly go through page 20.
See the submission which you have made.
Well,
based on that, you have created an impression that you have been held guilty of something in respect of which no charge was framed. you have been held guilty of something and you have been punished
My lord,
for which you
I
were
was,
not
I was no way responsible for that.
responsible is different.
No, my lord, kind of, for a minute, because it was a case concerning national, foreign national. There was a hue and cry in the, and subsequently after 2 years, my lord, the proceeding was initiated.
Very bad. It should have been initiated immediately thereafter.
No, but immediate steps were taken. Annexure 2, my lord, for a minute, my lord, kindly say Annexure 2, what was the
We will
allegation?
see everything.
My lord,
Why only Annexure 2?
Annexure 2, my lord, this is the foundation for such proceeding being initiated.
Yes,
If you also look at Annexure 2, page 20 for a minute.
yes.
At 6 or 6 diary number 6:15 4
You
p.m.
are relying on this.
My lord,
This session diary entry was made by whom?
entry was made by my lord, diary charge officer DSO, DCOs.
Under you.
Yes.
All right.
The allegation was different.
All right.
And there is not to that effect.
Yes, my lord. And where my lord, well,
That is a charge against you.
And therefore, only black mark. You should have been given some major punishment.
but the written FIR was filed on 2/12/2023. Immediately action was taken. And the culprit was nabbed even at the foreign soil.
We cannot exonerate you in writ proceeding. That too in writ. Yeah,
Item number
8.
dismissed.
May I please, your lordship? The appellant for your lordship is the chairman of the Fulban municipality. The no confidence motion against her was challenged for the honorable single judge for want of notice on her so far as the motion is concerned. Now, the honorable single judge, your lordship, I beg to draw your lordship's kind attention to page 24 before placing the provision to assist your lordship vis-a-vis the finding of the honorable single judge. Now, the honorable single judge, as page 24, the last line, was pleased to observe, next page, that is page 25, when the motion is proposed against the chairperson to be decided in the proposed meeting, the principle of natural justice demands intimation to the chairperson of such motion initiated against him. For this, absence of statutory provision would not be a hurdle, since the action proposed to be taken is affecting his right of unseating him from the chair. Therefore, in the demand of natural justice, this court is of the opinion that such notice is required to be served on the chairperson before moving the motion, along with other councillors in terms of clause C of subsection 2 of section 54. With such conclusion, this court sets aside the impugned notice of the collector and district magistrate dated 15th April 2024 under Annexure 1 series. And this is including the motion and the resolution and the requisition. It is made clear that the authorities concerned are free to fix a fresh meeting of the council on the motion in accordance with law with the service of notice on the chairperson. So I beg to challenge this paragraph 11 before this noble court in the writ appeal. Now, with your lordship's permission, may I place section 54, 54, madam, 54 of the Orissa Municipal Act. Of the Orissa Municipal Act, madam, section 54. With the lordship's permission, I will place both subsection 1 and subsection 2 up to clause C. And that is possibly at page 101.
Yes.
Madam, the vote of no confidence against the chairperson or the vice chairperson, where a meeting of the municipality is specially convened by the district magistrate in that behalf, a resolution is passed supported by not less than 2/3 of the total number of councillors recording want of confidence in the chairperson or vice chairperson. The resolution, along with the records of the proceeding at such meetings, shall forthwith be forwarded to the state government, who shall publish the same in the Gazette and with effect from the date of passing of the resolution, the person holding the office of the chairperson or vice chairperson, as the case may be, shall be deemed to have vacated such office. In the event of both chairperson and vice chairperson vacating office, the district magistrate or his nominee shall discharge the responsibility of chairperson till a new chairperson is elected. Provided that no such resolution recording want of confidence in the chairperson or the vice chairperson shall be passed within 2 years from the date of his election or nomination, as the case may be, and shall be moved more than once during a calendar year. Then second, your lordship will see, which has been in fact taken aid of to quash the no confidence motion notice, in convening a meeting under subsection 1 and in the conduct of business at such meeting, the procedure shall be made under this act, subject to, however, following the provisions, namely, no such meeting shall be convened except on a requisition signed by at least 1/3 of the total number. But the chairperson was elected in 2019, your lordship.
2019. So what is the
I'm sorry, my lord, 2022. I'm extremely sorry for giving a wrong statement. 2022.
2022. So from what appears from the order of the learned single judge,
Madam,
that now the chairpersons are appointed directly.
they are
from the
elected
public.
directly by
They are
the
elected.
on the ground of want of notice on me, obviously taking aid of Rule 4, which says if a motion is to be made, the council has to send it to the chairperson, not otherwise. So because the subsection 2 says also, in convening a meeting, the procedure in
You are the
accordance.
chairperson.
I am the chairperson. So therefore, here the court says the notice of no confidence motion is illegal for the reason of not having the notice on me, may not be for the other reason which your lordship has been pleased to observe just now. Now then, it is again relegated. My lord, this is not a case of relegation, because once you say the motion fails, for that year it can't be there. This is my contention. But you can't again have a meeting on that year, because the notice would have otherwise failed had it not been even with the intervention of the court, because this is illegal. The court holds that no, the motion is illegal. So once the motion is illegal and the annexure 1 includes the requisition and the resolution, entire thing is caused by the honorable single judge. Then direction for relegating to that position, in my humble submission, is not permissible, subject to what your lordship will kindly consider.
So you are not agreed up to paragraph 10.
Because that has been quashed. Motion is quashed, your lordship.
You are agreed by only 11.
11, your lordship, because a fresh notice has been directed to be served, and pursuant to that, a notice has been already served. It is fixed to 19. Therefore, I made a mention before your lordship.
Yes.
Yes, my lords. I'm appearing for the councillors, my lords. Out of 13 councillors, 11 councillors have moved this requisition for a no confidence motion. Now, my lords, as per the statute, there is no necessity to serve it on the chairman, because, my lords, he or she is not directly not elected by she is not a councillor, directly elected by the people, my lords. As per the statute, my lords, if we have more than 2/3 majority, then we can move this motion. And we have moved this motion. Now, my lords, this honorable court holds
No,
that
according to you, no notice is required to be served on the chairman.
according, my lords, the collector, we give the procedure is, my lords, we make a requisition, we give it to the collector. Now, my lords, the collector serves it on the other councillors as per the statute. Statute says only the councillors. Now, the honorable single judge also observes, yes, this is the procedure provided under the statute. However, because the motion is being moved against the chairperson, so it is of the principles of natural justice demand that this notice also should be given to her. So accordingly, my lords, the last line, the lordships may see the order. 25. He agrees that no notice as per statute be given, but therefore, in the demand of natural justice, this court is of the opinion that such notice is required to be served on the chairperson before moving the motion, along with other councillors in terms of clause C of subsection 2 of section 54,
With such conclusion, this court sets aside the impugned notice of the collector and district magistrate dated such and such under Annex 1 series. It is made clear that the authorities concerned are free to fix fresh meeting of the council on the motion in accordance with law with service on the chairperson, my lords. Now, my lords, we have a statutory right to unseat her if we have more than 2/3 majority. And our motion, our requisition has not been set aside.
No, see, I don't know, I've yet to examine the statutory provisions.
My lord.
See, if someone has to face
Yes,
a no confidence motion,
my lord.
that no confidence motion must be on some allegation
Yes, sir.
against him.
Yes.
Unlike your assembly or parliament.
My lord.
All right, you
Yes.
must have something
Yes, sir.
against him.
Yes, sir.
So on, and those things will have to be supplied to him.
Yes, my
or
lord.
her, so as to face the no confidence motion.
My lord.
So as to convince all the councillors
My lord.
that, see, these are the allegations against me.
My lord.
These are incorrect.
My lord.
But without serving a notice on the chairperson, how can you move the no confidence motion?
That is exactly what this honorable court held, that the notice be served, and it has been served.
All right, this is one aspect.
Yes, sir.
The other aspect is
Yes, sir.
that he has not been elected by you.
But my lords, the statute provides I can
Therefore,
unseat.
we'll have to examine the statutory provision.
My lord.
When he has not been elected by you, or she has not been elected by you, how can you remove?
My lords, that is the statutory
That is
provision.
the statutory that will have to be looked into.
And my lords, secondly, this was never the ground.
Therefore, after 2018 amendment,
My lords.
whether there have been amendments in section 54.
No, my lords. The
Why?
entire statute was
That is the
placed.
difficulty, your lordship.
The entire
Though they
statute, in
serve-
other provisions, if your lordship goes through the order, in other provisions, they have made amendments. This has been kept as it is.
No, then it's very difficult.
Yes, sir.
Sarpanch is elected directly. There also confidence will be passed to every ward members.
Ward members, my lords, it is, I'll check it up properly, my lords. Here, this has been brought to the notice of this honorable court by the state.
Which, my lord, the Honorable Chief Justice was pleased to observe that chance to rebut. I had also taken a stand in the writ petition, though there is a resolution saying that I am not doing this, that there is no material to back that, and nothing has been produced. That was one of the
Whatever,
ground taken.
Whatever.
So the resolution was a redundant
The-
resolution. That is what I
The
have
law
said.
requires that you must know what is there against you.
My lord, that
And then you must be, you should, so that you may be in a position to convince
My lord,
exactly.
the other councillors.
My-
that is exactly why your lordships directed that notice be served on them, and we have served the notice.
Difficulty is
We meets this collector.
the basic principle,
Yes, sir.
leave any statutory provision.
My lord.
The basic principle is that the person who appoints
My lord.
can remove.
Yes,
All right. So the person who elects can remove. Similarly, the person was not elected by this body.
my lord, your lordships,
The chairperson.
very
was-
consciously this has been left as it is. My lords, if your lordship sees para 5 of the judgment, my lords, they have amended other provisions of the act in that amendment which has been brought, but not this provision. Very consciously, they have given this power to the councillors to remove the chairman, my lords.
So we will hear on this point. But this meeting should not be held then.
Your lordships may see kindly see para 5, page 18 of the writ appeal. At page 18. Similarly, Ms. Mishra, learned ASC, while supporting the stand of the interveners, submits that legislation has consciously omitted notice on the chairperson, though for other purposes like removal of chairperson by the state government, the statute is prescribing service of notice on the chairman. Therefore, when it is settled that a thing has to be done in a particular procedure as prescribed in the statute, the same should have been done in
All
that
right.
procedure.
So you are going to hold
Yes,
this thing, rather the date is fixed on 19th.
19th.
Whether notice has been served upon the chairman or.
Yes, Palace. Notice has been served, date has been fixed, again a fresh date has been fixed to 19th. And my lords, we have a statutory right under the statute itself to remove her. And my lords, the law from Jyoti Basu's case, these are election matters, my lords. The statute prescribes her rights under.
These are not election matters.
No, my lords. Under the,
Election matters when it is notified and someone, the
this is also notified.
process of election
Well,
and no confidence motion, these are two different things.
these are municipal elections, my lords. These
Any
are-
election,
My lord, yes.
any election,
Yes.
that principle of non-interference by the courts in election matters
No, my lords.
applies in municipal elections and panchayat elections also.
Yes, my lords.
But
Even
this is not election matter. This is no confidence.
so we have already notices have been served by the collector upon her. And she has the right to rebut everything, my lords, on the 19th.
Yes, no, what is your contention in
Now,
that?
your lordship will see one more thing. 53 is there where the government can remove. There, your lordship was pleased to observe with regard to inquiry and other things.
53 is different.
Well, they have
53 is
not.
disciplinary.
As your lordship was pleased to observe, I will get a chance to rebut. Your lordship may see they have only given a notice of meeting, no resolution, no material. Your lordship was pleased to observe that if there is an allegation.
Is there any provision that along with the notice, the allegations should be mentioned?
Well, that provision itself, that statute, your lordship will see, along with requisition and the resolution, your lordship will kindly see. Notice they have not challenged. The Honorable Single Judge has been pleased to hold.
Where will you find the provision?
And that was on the basis of principle of natural justice that the Honorable Single Judge has been pleased to observe, and that finding has not been. Well, only thing I beg to humbly submit, the quashment of Annexure 1 has not been challenged by the contesting respondent. One more thing I beg to assist your lordship, your lordship.
There must be rules.
Rules it is there, that is Rule 4, your lordship may kindly see. Rule 4. Rule 4 at page. Rule 4, if I am correct, at page 251, my lord. I'll just, I'm not asking, I'm just assisting.
A rule?
Rule, my lord, page 250, your lordship, my lord. I think I'm holding the same book your lordship is holding.
Yes.
3 talks about an ordinary meeting. Then your lordship may see 4. 4 is at page 251. A councillor who desires to move a motion, this is a motion, your lordship, shall give notice in writing to the chairman, not later than 10 days before the day fixed for next meeting, and shall, together with the notice, send a copy of the motion which he desires to move. Then the other provisions are there. It can be rejected by the chairman if it is defective. Fresh direction can be issued and all those things. If your lordship reads this with subsection 2, which says in accordance with the rules, then it connects to Rule 4. Because subsection 2 of section 54 says in accordance with the rules, my lord. So therefore this has to connect. Then section 53 is very important. That empowers the government to remove, there which your lordship was pleased to observe. Procedure, inquiry, opportunity, everything is there.
53 is entirely different.
It's in a different field, operating in a different field.
53, see, if the councillors are of the view
Right.
that you are not discharging your functions properly,
Right.
or for certain things which do not fall within the ambit of section 53, the councillors may bring a no confidence motion.
That your lordship.
But they'll have to disclose that this is why they intend to bring the no confidence motion. Generally, we don't know.
In fact, Annexure 1 I have annexed. If your lordship looks at the resolution, that doesn't indicate the material. By saying that I am doing
Whether
this,
that is required under the act or the rule. No, that is not.
once the Honorable Single Judge has held, writ appeal is, my lord, on subsection, that is subsection 1, proviso 2. That is, there shall not be a motion once in a year. That is my ground of challenge, my lord.
That-
But my lord is pleased to observe
No,
that this
no,
very,
my lord is pleased to observe because of my lord's previous experience.
with regard to section 54,
That applies for Bihar,
my,
not for Odisha, because that my understanding is based on my reading of the books there. So the
one more thing,
statute book there.
one more thing I beg to humbly point out, there are two, may I just humbly
Yes.
point out one thing?
So that's, that ground is not at all sustainable.
But that, your lordship, that is not, that was not, never the issue also before the Honorable Single Judge. Before the Honorable Single Judge, there were two issues, namely, my lord, that whether there is a notice required on the chairman or not, number one. 54(2) in aid of
All it
rule.
we are coming, we will dispose it off. If that is the only ground, then we do not find any.
The second one was, may I just point out, my lord, whether there is any material backing the resolution or not.
Material, that is not required.
Well, that has to be put forth for me once they say that there is a natural justice, requirement of natural justice. Honorable Single Judge has said there is a requirement of natural justice.
So you can tell.
And the third aspect, your lordship was pleased to observe that whether this 54 becomes
natural
redundant.
justice, so far natural justice is concerned, there is going to be a no confidence, there will be a meeting, there will be discussion, they will be making charges against you. You shall have liberty to reply to that. So natural justice.
Charges, your lordship, may kindly see,
Already
I am sorry, this is in Odia.
We are coming back with it today.
My-
Yes, fair.
I'm obliged to. Paragraph 2, page 3 of the writ appeal. That is the only point I have raised for your lordship, whether paragraph 11 will survive vis-a-vis the order passed in paragraph 10 of the Honorable, by the Honorable Single Judge in terms of 54 proviso 2. That is the only point, my lord. I cannot improve upon it, my lord. That is the only point.
Tomorrow for judgment.
Obliged.
Item 9.
The other point which your lordship was pleased to, I think that will be
No,
examined in
this,
some.
this 54 will have to be, I don't know how.
No one has challenged it once.
That has to go.
Still remains.
That also is the same thing, direct election of the sub-coordinate.
I'll find out that for at least educating myself, and also if that is the point, that has to, because we are here to assist your lordship. Obliged.
Obliged.
Item number 9.
May I please, your lordships? Right, this is the Somoto PIL regarding this Utkal Balastram and the missing children, my lord. Pursuant to your lordship's order, last order, my lord, in compliance to that, my lord, we're filing an affidavit. We have filed an affidavit by the OP number 3, my lord, the Director, Women and Child Development Department, my lord, regarding the steps taken for the upliftment or for the betterment of the Utkal Balastrams all over the state, my lord. 17 Utkal Balastrams with 955 children. So this is an exhaustive affidavit filed on 16/7, my lord, today.
16/7.
Yes, ma'am. They filed it
File
today.
it today.
Filed it today, yes.
All that we will take up later.
E-filed, ma'am. But I can serve copies also, ma'am. And my lord, as far as one missing child was concerned, my lord, we are filing a complaints. Well, it's only a report by the police department that what steps they have taken to find out. He's supposed to belong to the place Jharkhand, my lord. They have made all possible steps, but your lordship, they will need some more time to find him out.
Only one child has not been rescued.
One child has not been rescued. Because we are not getting any details regarding his address. His father is not there in the electoral roll. So these are some of the
And
challenges.
probably the address furnished by him was not correct.
Was not correct. That is what we had also. CIG publications have been done in the state Jharkhand
All right, we will take up the matter later.
Yes, and your lordship wanted to know two balastrums which your lordship wanted to direct for visiting my lord. He has provided us with four balastrams. One in Narendra Kona Puri, which is in a good condition. Utkal Balastram Kantabanji Balangi, which is in good condition. And one Utkal Balastram Sonpur, which is in little yet to be improved.
Not little divorced.
Yes, poor condition.
I mean, actually, last 2 years back, we have adopted this Judicial Valasam. So we are, it is in the poor condition, little poor condition or in comparison to the other Judicial Valasams.
Which one?
One in Sonpur, Subarnapur, one in Fulbani, Kandamar. Kandamar.
Give us the,
I'll give the list. I'll give you.
it is stated by Lord AGA that an additional affidavit has been filed on behalf of
The Director, Women and Child Development Department.
the Director, Women and Child Development,
OP number 3.
bracketed number 3, on today online. So stop this matter on 2 weeks. Where is that? Fulbani?
One is in Puri, Fulbani and Sonpur. One in Sonpur, one in Fulbani.
Near Bolangir. So the best ones are in Puri.
In one is in Puri and in one is Balangir,
No.
Kottabanji.
Best ones as 3 you said.
2.
No, you are saying these are the worst, which they have taken up.
2
Or
good
am I
and 2
mistaken?
worse. 2 good and 2
So
not
2
very
good are Narendrapur Puri, Narendra Kona Puri and Cuttack.
No, Kottabanji, Balangir.
So these two are the best. So Narendrapur, Narendra Kona Puri and Kontamanji Balangir are the best. And the worst are Sonpur,
Kanpur
Subarnapur
and
Kandhamal Fulbani.
Fulbani. Oh, close by. Fulbani is how many kilometers from Sonpur?
Around 60-70 kilometers.
That can be visited any day that event.
That you have indicated in your affidavit.
No, that we just received now. I can give it as a memo, my lord. I'll place it. Lordship is fixed a date.
2 weeks.
Oh, bless me.
Item number 10.
My lord, actually same matter has already adjourned to 25th July. Kindly adjourn the same matter to the 25th only.
Which is this matter about? What is this matter about?
The education volunteers, after their disengagement, were
So this has been adjourned to?
this has been adjourned to 25/7/2024.
This is
Similar matters.
matter on 25/7/2024, along with
Give one number at least.
Your Lordship, last order, same batch of cases have been posted.
along with WPC number 25046 of 2021 and other analogous matters.
Madam, your name, please.
Jayanti Das.
Item 11.
11, actually I am on behalf of Sanjay Kumar Das. He is not well. So kindly make it after 1 week.
1 week as requested.
Item 12.
Oh, bless me.
My lord, item number 12, additional affidavit has been filed yesterday.
It has not been tagged up. It may be brought on by tagging on any day my lordship pleases.
No, what is this matter about?
My lord, it is a Puri PIL matter whereby,
PIL.
my lord, funny cyclone in 2019. my lord.
Yeah, no, that was regarding the petition for the device. So that was a later thing. This is a PIL. That is, till date, it has not been done.
How can this be a PIL? How can this be a PIL? This is your individual interest. Come to your prayer portion.
My lord, there are multiple people who are suffered.
Multi people, then they can come. The people are approaching. You are saying as to why financial assistance shall not be disbursed in favor of the petitioners and other beneficiaries.
My lord, let it come in another day. Will satisfy your lordship for admission.
Where is the question of satisfying? This PIL is not maintainable. This is your personal interest.
Sir, this is the case, if your lordship permits. I'm sorry, my lords, I was held up.
Now, how is this PIL maintainable?
My lord, this has been raised. The PIL has been, my lords, filed by the entire, my lords, an association who has been espousing the cause of the entire area, my lords. And this is, my lords, a grievance.
Mr.
And
Pal,
this has been,
Mr. Pal,
my lords,
association as well as the
Some-
other petitioners also, private parties.
my lords. Some of the private parties are also there. They're
Sir,
affected.
you can file writ petition. Why PIL?
Direct writ petition. My lords,
File PIL
my
petition.
lords, I, lordship may only kindly observe that.
Union Council appearing on behalf of the
Grateful.
petitioner seeks permission to withdraw this writ application in the nature of public interest litigation with her liberty to the petitioners to raise their individual grievances before appropriate forum in accordance with law.
Grateful.
Application is accordingly. Yes,
Item number 13.
with the liberty. Yes, item.
13.
Item number 13, my lord. I'm sorry, my lord, yesterday I felt a little bit uncomfortable. I went away.
What happened?
Hey, because of a long gap of not eating.
Are you a diabetic?
None.
All right. Yes, what is the matter?
But yesterday, my learned friend has placed before you. This is a matter demanding additional performance of the security. Initially, I came before your lordships, telling that there is a contradiction in the clause 221. It has been repeated twice. One speaks of additional performance to security, another is silent about that. And there is a clause, interpreting clause, that in terms of clause 7, agreement clause 7, it would be given. Agreement clause 7 doesn't speak anything about additional performance of the security. Then your lordship, in the initial first matter, because a representation was given to them that there are contradiction, how can you demand additional performance security in view of the fact that the interpreting clause says that you refer to agreement clause 7 and agreement 7 doesn't speak. They rejected it. Then again I came. Then your lordship issued notice and gave them 2 weeks time to file counter. In the meantime, they have disposed of my representation, rejecting it and directing me that you deposit additional performance security within 17th. Otherwise, your entire money that you have deposited for performance security and the earnest money, that would be forfeited. In the interim application, I am there before your lordship that since they have not yet filed the counter and notice has been issued, forfeiture of this will entirely prejudice me and result in cancellation of my tender, where I have become L1. So in addition to what he has submitted, may I refresh your lordship's mind?
No, but if we remember correctly, we were noticing a page.
63 and 64.
63 and 64.
63. So 60,
Six-
why is that page blank?
Well,
Totally.
I don't know. This is what we have received. And in my first representation,
And
they disposed of.
That is incongruous also. Please.
Yes, it is incongruous. Dear Lordship, may kindly look at the last page marks, internal page. Has your Lordship got it?
Yes,
Page 63, internal page 32.
yes, just see. 63,
Yes,
if we remove 63, suppose if we remove 63,
then 64 will prevail.
oh, no, I'm not saying that. If we remove page number 63, then everything becomes this thing logical.
Yes. Except the fact that, my lord, 64, 2.21, 22, your lordships.
Why have you not filed your affidavit?
There's 2 weeks time to file the same.
So
And
we will give you 1 year time to file counter affidavit. We will stay the proceedings.
No, only I am paying for only 10 days time.
The time was already granted.
Yes.
All right, then don't take any step.
But here is the case, they have acceptance, this reward, and they are not objected anything about page 63.
See, our problem is that we cannot decide their case in their favor or against them.
Nothing give below.
Because we were directed to file affidavit, we have not filed.
They prayed for another 10 days time, we'll buy 10 days, we'll buy.
Near about,
Please find out what is there about page 6.
yes. I saw decisions of the apex court. I couldn't get it. But one decision I found, which may help your lordship from Uttarakhand High Court. I don't say that with trepidation I place it, my lord, because it is a persuasive value.
No.
My lord,
Doctrine of
your lordship,
committee is also there.
kindly look at, except the previous parts, my lord, relevant portion will be 20, paragraph 22, my lord. 22, 23, 24, 25. Has your lordship got it?
Yes.
May I place it? As your, may I be permitted to place it?
So from this, it appears that these tender authorities are in the habit of creating confusion. Here also they have done it similar time.
Yes.
So therefore, forfeiture at this stage would make the, and cancellation would make the L1 acceptance redundant and writ application would become infructuous. Then therefore your lordship may kindly protect me.
Let's say, let them then depute the subject result of the outcome of the case.
Right.
What I'm saying then, let them depute the HSI amount because clause is there.
Because-
64 is very clear in this respect.
So because of failure, you should.
No, my lord, this clause is very clear in this respect. Clause is very clear. Let's say page 64. Only confused that this addition to that page 63, 64 is
Lord,
saying
it will
detail.
not prejudice.
Whether
Lord,
63 will prevail or
because
64
they have
will
a
prevail.
right to right to deduct 5% of the.
That's why I'm telling you, let them depot it.
They from the running bill, they will go on deducting 5%. So.
So what I'm saying, my lord, so 10 days nothing.
Sir Mohanty, you are addressing me, he is addressing, Mr.
Sorry, I am not. Okay.
Sorry.
Apologies.
No. Do it.
Well, what I'm
Right.
praying, let them deput whatever
No.
amount they are subject to outcomes. Other lordship may give 7 days time then.
Yes,
7 days
2
time.
days time. If you want, we can give 2 days time.
7 days within next week we'll file. Lordship may keep it to Tuesday or Thursday.
This by
23rd, 24th.
No counter affidavit has been filed on behalf of the opposite parties. So stop, list this case on 1 week. So stop. It is. The status quo order will serve your purpose.
Stay of that letter. because they have-
Well, what will happen, what my prediction, my status quo may be prejudice both because they will not do the work,
All right.
will execute this
All
one.
right. Let's take. What is your date order data?
The annexes,
9.
my lord.
9 and 6.
With the next date. The operation of the improved communication.
6 and 9.
Improved
9 is forfeiture.
communications dated 14/6 and 7/6 and 26/6/2024 shall remain state.
And annexure 6.
Annexure both.
Annexure. Oh, right. But only I pray that can your lordship, because your lordship has fixed the other matter to 24th, yesterday's matter. It can come on 25th.
On 25th, 25th.
Yes. Yes. Already I will immediately will serve. Yes.
Obliged.
Item 14.
Yes, Mr.
Wait, please, your lordship. But this is a case where actually the tender was floated for a particular work. That way back in 2023. So initial tender was cancelled. Subsequently, another time it was floated. Then the petitioner participated along with 2 others. So he became the L1, having less 8.5%. And on negotiation was held. Negotiation, he was also found to be for the petitioner. The chief engineer recommended that he should be awarded the work. At this stage, this annexure 1, the letter has come. If you lordship kindly see the letter. Annexure 1. At page 17.
Yes, what can be done?
The cancellation instructed by the Government of Works Department, that's so and so. But my respective submission is that the law has been well settled now in the matter. Cancellation, they have got a right to cancel. I don't have a right to say that, no, you cannot cancel me. But you must give reason for cancellation, and that reason must be reasonable enough for the court to appreciate that is such a thing as done. Termination of a contract or tender, which is in the realm of judicial review, as has been heard by the Supreme Court in the recent decision delivered on 9/7, of 2024. Your Lordship must have seen this judgment, must have gone through it in fact. Kindly give the judgments. Chief Justice, it took me two of the judges, 3 judges bench, elaborately dealt with what is the fairness in cancellation. Because you floated a tender, you are trying to cancel it. Pre-tender, post-tender, all those things have been elaborately discussed. If your Lordship kindly look at page 37, paragraph 39. The pages are at the bottom, my lord.
Yes. $39.
Yes, my lord.
What is there?
Sir, clause 2, if you Lordship turn top, my lord.
Yes.
Exercise of jurisdiction in disputes at the stage of prior to award of contract. It's an action under writ will lie even at the stage prior to the award of a contract by the state wherever such award is imbued with procedural impropriety, arbitrariness, favoritism, or without any application of mind. In doing so, the court may set aside the decision which is found to be vitiated by reasons stated above, cannot substitute the same with his own decision. But even clause 3 says, exercise this jurisdiction after the contract comes into existence. The LRCs have dealt with a number of decisions. And at page 79, if you see the concluding paragraph, para 126. This is a public tender. Public law element actually is on the face of it. Para 126 at page 79.
Yes.
The sanctity of public tender lies in the role in upholding the principle of equal opportunity of fairness. Once a contract came to existence through a valid tendering process, its termination must adhere strictly to the terms of the contract, with the executive power to be exercised only in exceptional cases by public authority, that too in oath. The courts are duty-bound to judicially protect the sanctity of any tender that has been duly concluded by ensuring that the larger public interests upholding bindingness of the contract are not sidelined by capricious or arbitrary exercise of power by the state. It is the duty of the court to interfere in contractual matters that have fallen prey to an arbitrary action of the authorities in the guise of technical fault, policy change, or public interest. 127 also, they have taken note of this arbitrary or unreasonable termination, undermining this expectation, erode the trust of private players from their public procedural process and tender. Once the contract is entered, there is a legitimate expectation that the obligation arising out of the contract will be honored.
No, but this 126 does not apply.
Well, that is after the contract. But I have also cited, if you Lordship, the paragraph which says before the entering into contract.
No, before the entering, that is different. You were reading with paragraph 58. The previous paragraph, if you were reading.
37.
50?
30, at page 39, it is mentioned.
39. So that was.
Scope of interference has been dated in para 55.
Yes. The exercise of jurisdiction in disputes.
Stays prior to contract.
Yes.
That was also indicated the court has
not,
to.
It does not deal with a situation where the contract is the tender process itself is cancelled. The notice is itself cancelled.
So that was also taken note in another decision. Here it has been dealt with. Sir, there, kindly see this, it's 21. I have given a lot of decisions on that, all relating to the prior to contract.
No, prior to contract means show us a decision.
Yes, yes.
Where
Lordship said you should give opportunity to the person who has become L1. You must give reason for that. Can you look at page 64 of 2021, volume 19, SCC 706.
Yes,
I have given the citation.
yes, please, which paragraph?
64. It's okay.
Which paragraph?
So can you look at paragraph 41, page 64.
Yes.
At page, sorry, page 42, paragraph 42, page 64.
Yes.
An analysis of the aforesaid judgment thus reveals natural justice is flexible tool in the hands of the judiciary to reach out in fit cases to remedy injustice. The breach of ordinary term rules cannot by itself, without more, lead to a conclusion that prejudice thereby caused. And paragraph 43 at page 65. Judged by the touchstone of these tests, it is clear that the respondent has been completely in dark so far the cancellation of the award of tender in his favor is concerned. PW
Has been passed by the tendering authority without giving an opportunity of hearing to the petitioner. Where is this law laid down by Supreme Court anywhere? That before cancellation of tender, L1 has to be given a notice. You show us one decision.
But there, if your lordship looks at, right, so there are two decisions there, lordships have referred to.
Here also.
And interesting, they must assign reason. You cannot just cancel if you at whims and caprice.
Where is that? Where is that? This is what we want.
Yes, that is
Because
there.
if we today we hold that, like we are of the view that this is the first decision.
Sir.
Where this court has held that before the order of cancellation is passed, the tendering authority has a duty to give reason, to give opportunity of hearing.
If your lordship looks at paragraph 7 of that judgment, referring to Sri Ganesh construction. Paragraph 13 has been quoted, Marad. in view of the reasons assigned in the foregoing paragraphs, it appears that in that decision, Sri Ganesh,
No, what was there in Sri Ganesh?
Sri Ganesh, same thing. Tender was floated, it has been cancelled without any
Do you
reason.
have that decision with you?
Sri Ganesh, Maran. Sri Ganesh also have given. It is
Again.
first one,
You have given.
First one.
first
Okay.
judgment.
No, this is again the High Court.
Yes, High Court.
Sri Ganesh is again High Court.
Right.
He want to know whether there is any decision of Supreme Court which lays down that if the tendering authority decides to cancel the tender, it has to give.
So
to
with
its
due respect,
successful-
Marat, can I just make one little submission, Marat? This judgment was challenged before the Supreme Court. Supreme Court confirmed it.
Where is that?
Paragraph 11, Marat.
Paragraph 11 of what?
Paragraph 11, the judgment of Justice Sadani, Marat.
Oh, where is that? Whether that was dismissed in limine?
Sir, this is
Where-
that serial number. No, serial,
Because the
serial number 5.
serial
Oh,
number
that-
5. Serial number 5. Oh, serial number 5 is the same which you are showing.
No, the order passed by Sri Ganesh Construction
No, the order.
have been
passed by
challenged
the-
before the apex court.
Apex court, whether reasons have been given or what is that order?
That order I have not.
Yes, because it's it may have very, and for the first time, we'll be laying down it has been laid down, of course, in case of Ganesh
Yes,
construction.
madam,
and-
right.
But I am not such decision,
Supreme Court judgment.
any Supreme Court decision.
But here actually they have referred to two judgments.
And
Sudhir Kumar
any
Singh
other
and
high
also-
court. If any other high court has taken the same view, that before cancellation of tender,
Right.
opportunity is to be given to the to L1. I am.
Sir, candidly, must say that L1 doesn't have a right to say that I should be given. I cannot claim that I should be given. But cancellation, what let me kindly see.
There are two aspects. One, your right to be heard,
Right.
and two, their duty to record.
Give reasons.
To give reason.
No reason has been given.
See, we can decide it, we should consider this. At least,
Reason, Lordship kindly see page 18 for a moment, my lord. 18, page 18.
yes,
Page 18 that the cancellation order, in that cancellation order, one proceeding is enclosed, my lord.
Yes.
And he has not enclosed that proceeding.
Sir, kindly see.
Have
Just a
you?
minute, sir. Kindly
No, I
have
don't have.
Page 18. Page
Presently, I
18,
don't have. My lord,
file your affidavit.
my lord, my lord.
4 weeks. As requested on behalf of the AGA. List this matter on 4 weeks so as to enable him to file counter affidavit. Is there any interim order?
Interim order.
No, my lord.
They have not
This is
floated,
fresh matter.
they have not floated any further note.
2 weeks. 2 weeks you can do.
My-
Simple matter. 2 weeks.
You know, may keep one observation with due respect, Malada, so that subject to your lordship's appreciation. That in the event they float a tender, fresh tender,
No,
I
it
may
will
give
come after 2 weeks.
opportunity.
Within first 5 cases, it will
Right.
come after 2 weeks.
That's
If
exactly
something
what's
happens in the meanwhile, you can.
Right.
Item 15.
Next item also. This matter relating to revalidation of the NOC, which was granted in favor of the petitioner institution for imparting BSc and nursing courses. But here, what has happened in this case, this institution is continuing since 2005. Year to year, NOC has been obtained. Your Lordship has dealt with that other matter also, detail on that. So I will not take your Lordship to the procedural part of the law on the subject. Only thing I would like to submit, kindly have a look at Annexure 1 at page 49.
Just now they have solved the copy, my lord.
No, I've solved a copy. Mr. Nasing was, I think, Sir Rajani Mahanti. No, not connected, but same type. Not connected. The relief there was different. Here the relief is different. The actually 24, 25, they have now notified, your Lordship remembers, amended the order by passing the schedule that has been given. That schedule they have prepared. Now they gave me the NOC for the enhanced seat on 16/1/2024. I again immediately applied for NOC for 24-25. That was given for 23-24. So I have not taken admission for 23-24. There is a specific provision. If you have not taken admission in the student, you can make an application for revalidation. So I immediately applied for revalidation because the last date was already over for 23-24. So if I get revalidation for 24-25, I can take students, which is permissible under law. My application has been kept pending. But I request them, revalidate it, grant me the opportunity because 31st January is the last date. 31st July. So if they don't give it, I cannot get it. They have, like Savitri Satyavan, they enhanced my seat, not granting revalidation. So I am neither here nor there. Again, 1 year I cannot utilize that 50 seats. And this 2005 institution, which actually has got a very good track record.
Yes.
Just now they have solved the copy, my lord. Maybe taken up 1 week after.
Tomorrow or day after, any day.
We can take up the matter tomorrow or day after tomorrow.
Next week, my lord.
Instruction,
We
online
take
instruction.
instruction.
It's a seek instruction. What are you doing? See,
Yes, my lord.
you had already granted NOC.
Hmm.
You granted NOC on 1st of January or in January. They could not take admission. Now you have to revalidate that for the subsequent year. And you are delaying that also.
I'm not asking for
Tell us.
23-24.
Yes.
We will see what can be done.
Yes, on Friday it may be taken up. I will take it.
You try. It is
Yes,
not that-
yes, ma'am. Day after tomorrow.
Just make an attempt. What is happening in such matters?
Yes.
This is one. And the other thing, that why every year this NOC business? Why? See, you can have a system, you can have a mechanism to inspect colleges whenever you require to find out whether the NOC should be allowed to continue or not. But once you grant NOC, unless some deficiency is reported, why should be discontinued? Every year NOC unnecessarily, that is wastage of your this thing, energy and time and if you want fee, there will
We'll
be
suggest also.
twice.
Because when you're not able to grant permission or time fixed.
Yes, ma'am.
What is the use of that?
So you can do that. So how much amount do they take for revalidation?
No, revalidation, if they don't give it, I cannot admit students. Now students are going.
Fees when you apply.
For renewal.
60,000.
60,000.
60,000.
60,000 for new, and for renewal it was 20,000 for us.
Yes. So for 20,000, they can give you 25,000.
Yes, I will take it.
Don't compel them to see every time every time, every year, taking this.
And they have granted final recognition also. Once final recognition is granted, only revalidation.
Where is the provision for no objection? Do you have with you the statute
Regulation, they have got a
Yes,
regulation. also.
there is a guideline, man.
guidelines?
Yes, ma'am.
So, improve your guidelines, otherwise don't compel us to frame guidelines. All right. Why necessary every year? I have not been able to understand. That why NOC every year? Is there any compulsion? for
Sir,
that?
actually, Annexure 1 is the circular they have issued. As per section 16 and 17 of the Act, they say until you get a final recognition, you have to apply every year. Once final recognition is granted, it is for the complete course of 4 years. For 4 years, you don't have to apply. So now I have got a final recognition as well. So there is no question of applying for NOC again. So it has to be revalidated.
See, what is the meaning of NOC?
NOC actually, after they grant NOC, they'll get affiliation from the university.
What NOC means what?
For admitting students.
NOC, no objection certificate.
Yes, NOC stands for no objection certificate.
For establishment of the institution.
Establishment of the
Yes.
institution.
If
See,
the-
there can be 2, 3 NOCs can be for different purposes. One, NOC for establishment. Two, maybe NOC for admission of the students for particular academic session. So if that is a statutory requirement, then that will have to be taken if it is governed by AICT or what?
INC, Indian,
DMET.
so far as nursing is concerned, that Indian Nursing Council, so far as pharmacist is concerned, the pharmacist council is there.
Different councils.
Different councils. Indian Nursing Act is there. So far as pharmacist is colleges are concerned.
See, you grant NOC after you are satisfied that this infrastructure is available.
Inquiry is conducted.
Inquiry conduct, the infrastructure is available. So unless some certain deficiency is found, if any deficiency is found, you can warn, you can cancel, whatever.
They give a show cause and then they cancel, then they have the power to do it.
There is a provision under INC Act, that's perhaps that is section 13. Whenever the INC, Indian Nursing Council will desire, they can inspect the institution. If
Yes.
any deficiency is found, they can point out and recommend to the state government to derecognize them. There
Please
is
examine this aspect, Mr. Mishra. NOC,
NOC has been granted.
no, examine the legal, the legal aspect of.
Legal aspect of
grant
NOC.
address on that. If required and you also get instructions that this is what we are thinking. That if we find that there is no requirement of NOC every year, if you don't do that, we will do that. All right. If you don't make necessary corrections, or if we are satisfied that this NOC, you have put this requirement unnecessarily, then we shall issue guideline.
Right.
We shall direct. Otherwise, you correct yourself. You make amendment, you may make amendments, you can improve your, but every year NOC,
So I'll satisfy you.
please
Right.
examine the
Right.
purpose of grant of
Right,
NOC.
legal sanction.
1, and then purpose of grant of NOC for every year. 2, and 3, once you are saying permanent recognition is granted, no NOC.
Right.
On 3 issues.
The three basic things, my lord, I'll just.
NOC for that particular course.
Right.
Start a new course, again that we will start.
NOC is right.
No, if you start a new course, then it's a different thing. Yes, if you increase seats, of course, for that also, NOC may be required. Because NOC is no objection for this thing, no objection C. No objections are also required because the state government sometimes has to decide, or the council has to decide that in particular area, there are already
Yes.
so many institutions.
Yes.
Therefore, there is no requirement of further institution. Therefore, they may decline to grant.
Correct, they
UOC.
can do it.
So these are the
Further aspects.
one of the purposes for declining or for accepting or granting. So
Absolutely.
please address the legal aspect of it.
Item number 16.
It's complied.
Order complied.
Complied.
Great.
Item number 17.
In item number 17, Lordship may kindly look at the order passed by this honorable court, my lordship. The order passed, it says a PIL, not order it at page, not 16 of the brief, not. Page 16, the petitioner's notice, oblique representation, right annexure 5 series, will be examined by the Tahsildar Contapada and after notice to the petitioners and opposite parties, not giving them a hearing, a reasoned order shall be passed, not later than such and such notes. Here is a case, not a legal notice was given, that is annexure 5, which is not sought to be disposed of by the Tahsildar Millers. And in that notice, the villagers have given a notice through a pleader, Millers, saying that in 1971, some lands were acquired by the state government for the purpose of Millers canal, Millers. Now they say during that subsequent major settlement in their 1997 or something like that, those lands, even though possession has been given to the Millers drainage, it has not been recorded in the name of the state government. For that,
Just start. Where is the order? I just missed to.
yes, sir. Order is at page 14, read out the right name, Millers.
Page 16, yes.
16. Paragraph 1. The petitioner's notice oblique representation annexure 5 series will be examined by the Tahsildar Contapada and after giving notice to the petitioners and opposite party number 8 and giving them a hearing, a reasoned order shall be passed not later than 14th August, such and such Millers. Here, Millers, this notice has been given to all Millers. And the land was acquired in the year 1971, Millers, for the purpose of excavation of a canal, Millers. And the allegation of the villagers through a pleader notice is that even though lands have been acquired, now those lands have not been recorded in the name of the state government by taking advantage of this.
No contempt is made out, sir. Sorry. No contempt. No contempt.
The direction is given to by the honorable court to the opposite party. The direction is given to the opposite party to comply the order. To dispose of the representation, wherein the complaint is that even though the land has been acquired and possession has been delivered to the state government, due to non-recording of this land.
No, nothing is there. Because the court clarifies that it has not expressed any view in the matter.
That is the merit, my lord.
So that is the merit.
They have to dispose of that accordingly, either.
Representation has been examined.
No, notice has been given. Now the Tahsildar insistence of the matter, the original owner has given objection saying that his entire land has not been acquired, only part and parcel is acquired. And so he has accordingly sold some properties. And this relates 71. So Tahsildar needs more time because records of 71 will be.
Dispose of that. Dispose of that. Let them dispose of that. Hearing is going on.
Yeah, dispose it off.
Yes.
Following is the order passed by this court, violation of which has been raised in the present contempt application. Top. We have been informed at the bar that steps have already been taken for
finalization of the dispute, that disposal of the annexure 5.
What is annexure 5?
Annexure 5 is a legal notice given by the villagers
stating that the lands which have been recorded in the name of the private parties should be examined and recorded in the name of the state, because they say that it was acquired as back as in the year 1971 by the state government. That is their allegation. So Tahsildar in session of the matter, he has called for records from the drainage division with regard to the notification. Yes.
Already been taken to examine the issues raised by the petitioners in the PIL. And notices have been issued
Hearing is
To-
also going on.
the concerned persons. So Land Council for the, how many notices have been issued to how many persons?
The petitioners and the private landowners.
How many private landowners?
I think
How many private landowners?
only one, OP number 8, because there were direction to,
OP number 8.
Only 1%.
yes, no, we have given, because of the order, we have given notice to one only, OP number 8 only.
Okay. Land Council for the petitioner. Land Council for the petitioner states that, admits that hearing of the matter is going on. Also, in such view of the matter, the contempt proceeding stands stopped as non-compliance, if any, cannot be said to be deliberate. Yes.
Or orders item number 18.
Objection to the limitation.
What is it delayed?
Delay,
17 days delay.
517 days. But after deduction of that period, as per the Honorable Apex Court direction, so motor proceeding, it is 258 days. The matter related to that Narsu Pradhan, similar matter your lordship have posted to 22nd 8/2024.
What is the issue involved?
The Narsu Pradhan matter, my lord.
Narsu Pradhan is?
Narsu Pradhan, that the entire work charge period to be taken into consideration for regularization and pensionary benefits.
Retired worker employee, whether they are entitled to get pension and
So
pension.
matters have come
That
for
is
admission.
issue. And
Yes,
in
my lord.
case of,
And posted to 22nd August 2024.
and your lordship, the lordship is aware of the fact
We consider it time.
that in
Stated at the bar that criminal matters about which is only 2024 for
22nd, my lord. 22nd 8
22nd,
2024.
22nd of August.
My lord.
This case on 22/8/2024, could you give us the number?
My lord, WA 432 of 2022. Of 2022.
Your batch of cases.
my lord, that's of cases, but
Case number 32 of 2024, batch on 22/8/2024. The application for condemnation of delay shall be considered on the said case.
my lord, because hurdle is delay, your lordship. Bar is delayed until unless delay is not found on your lordship, then merit of the case cannot be. That is the hurdle.
This is the order.
That is no delay, your lordship has delayed to condone, for that reason your lordship also clarifies. My lord.
We shall consider the
My lord,
time of admission.
time of admission.
See. Have you examined Bihar's decision?
Yes, my lord. That is in Uday Pratap's case, my lord.
Full bench.
Yes, my lord.
Bihar-
Bihar's decision later carried to the Honorable Apex Court. There, the Honorable Apex Court said the work charge, the appointment in the work charge establishment, not being a substantive appointment, that period of service cannot be taken into consideration for regularization. However, to make somebody eligible for minimum pension, the so much so period of the work charge shall be taken into consideration to
That is the Patna High Court
Yes.
also. full
Yes,
bench.
my lord. That is also that
And Patna High Court full bench is because of some decision of Jharkhand High Court. Because some work charge employees who were there in Bihar before bifurcation, they were granted benefit in Jharkhand.
yes.
In that background, the Patna full court, full bench had to take that decision. This is,
And here also your lordship will consider that they have already availed the EPF benefits in terms of the executive instruction basing on which these watch charge appointments are given. They have already availed that EPF benefits. So whether subsequently they can claim for pensionary benefits in terms of the OCS pension route, that is also to be seen. And moreover, in a case where during their service period, they never claimed for regularization. And after 15 years of their retirement, they have approached the Honorable Court and the Honorable Court has disposed of the writ petition that your case is squarely covered by the case of Narsu Pradhan. So the entire period of the work charge has to be taken into consideration for regularization.
Your Lordship, in Orissa, there is a work charge, the employee service condition and instruction is there. So we are guided by that instruction. So in this case, Your Lordship, in case of Orissa, so many work charge employees case allowed and thereafter the state government preferred appeal, SLP was dismissed, that order was implemented. And in recently, Your Lordship will see when similar matter went to Supreme Court has cautioned the state government that why you are filing this type of petition, be cautious about that judgment. I have also given in a bunch of cases, judgment, Your Lordship. So that case is different. That is Your Lordship. Here is the work charge instruction is here in the state of Orissa.
Item 19.
Here there is a delay of 54 days.
54.
Yes.
I
A notice was issued, they have appealed.
I have appealed. On behalf of respondent 3 and 4.
Item
19. One.
My lord, Your Lordship may kindly give me 3 days time, my lord, I will remove that.
5 days receipt of not some copy.
Copy to government, my lord, I have served.
Okay.
Okay.
Because there is some other defect. 5 days that. Defect number 5 days ignored and a copy of the appeal memo has been received. I have for condemnation of people. The filing is filed. The central application has been filed. From application of filing. Third is demarcation limit on the applicant. Also appearing on behalf of the respondent.
3 and 4.
3 and 4.
My-
Respondent. That's why it is now. For ordering the deal, and delay the order, the application is allowed. Next admission, have you served a copy of the appeal?
Yes, I will serve, ma'am. I have not yet, sir.
This is appeal on 23/7/2023. It appears on 30/7/2024 of that admission. Copy of the appeal memo be served on the council for responding, appearing to responding of the appeal in court before the set date.
May I pray that there is another defect in the cost title itself, my lord. Lordship, kindly have a glance at the impugned order
and on the answer 8 at page 43. Page 43, man. The cost title is opposite note 2. There is director of a higher secondary.
Order impugned. What is wrong in the order? Why should we interfere?
That, my lord, your lordship has kept to 30th. I will satisfy me.
No.
Today, my lord, I am not ready.
All right.
Item number 20.
Madam, in the cost title, there is defects. The previously in the read petition, there is the director of a higher secondary education. Now in the respondent note 2 has been added as a director of higher education. So director of higher secondary education has not been made as a party here.
I will correct that.
So that is the defect you were saying you want to remove, but the stamp recorder has not pointed out.
This is the defect.
This, but in this team officer, the counsel for the appellant, has removed the defect, the apparent defect in the cost title of the data piece. Before, by within 1 week. You have a copy also within 1 week?
Yes.
You've been asked to file a appeal under section 10A. So that
Yes. That I will satisfy, that I will satisfy, my lord.
You
Because
file
the
a
post
appeal
is
and-
unaided. The post is unaided. 10 is applicable.
There is
to
no
aided.
supposition. The institution is to be added. An institution is
That I will satisfy.
yes.
Item 20.
In item 20, notice on limitation was issued on 18/6/2024. Let's see, there is a report.
you can include no such person. You have to take such steps.
We have issued, notice was issued as per the information given in the original application.
What is the address?
Address or village address as if
Village address?
that you'll also may see that in read petition address which was given, that address it is given, including her office address.
Oh, this is
Vinodini Pradhan. Madam. You'll also see the read petition. First page of the read petition. Well,
so where is the first page of the report?
read petition with that has come along with let's make court title.
The petition is there.
Yes.
The petitioner is working or not?
No, madam, retired.
Retired.
Madam.
So you've taken to village Gracindia, whatever. That could be a typographical error. I don't think there's anything as bloody magic.
Well, may you also may see that is also in that we have to just.
No, you have to just when it has come back, you apply your mind. I don't think there is anything.
Find out.
Yes, madam.
Find out.
Correct and present. Right?
Madam.
The registrar has pointed out that official limitation matter is written answer.
Madam, may I submit one line, madam? May I submit? I can serve a copy of the writ appeal to the counsel who was appearing before the honorable single judge.
May decline. Make an attempt. It shall be at liberty.
Sir, additional government advocate is at liberty to serve a copy of the appeal memo. The learned counsel who was appearing on behalf of the respondent in the writ application.
My lord,
Additionally, he shall.
I'll take step.
Also take steps in case of.
He refuses.
He is also required to take steps for
Your lordship may fix it to next week. If he refuses, then I can take.
the case on 23/7/2020.
Well, on that date, I will take.
I'm for the petitioner. Yes, ma'am.
Discuss out.
I don't. Urgent matter is there. It would not be listed meritorious students. It would not appear after the exam. MS Law University.
Which examination?
Law.
Why could he not appear?
Due to vindictive attitude of the university authorities.
How is the matter urgent
If
today?
it can be taken up today on board last item, urgent matter.
No. Why didn't you make a mention yesterday or?
Your lordship, I could not make because of due to listing problem, holidays were there.
What is this? What is this examination about?
Semester exam of law degree, MS Law University.
What is the date of examination?
2 exams are over and another exam is there day after tomorrow.
Then what is the purpose when the examination is over?
Your lordship, they're not allowing her to appear in the exam.
Then the
Form fill-up,
examination, the
they have done
papers are
form
already
fill-up.
over.
Form fill-up they have done.
Mr. Counsel, the papers are already over. Why don't make a mention now?
Another 2 papers
Make a
are-
mention tomorrow morning.
Item number 42.
In item number 42, my lord, unfortunately, I have not addressed your lordships. I will take only 10 minutes on behalf of the petitioner side.
Yeah.
But the moot question in this case is, as my learned friends have already argued before your lordships, that there is no distinction between pre-2013 appointees and post-2013 appointees. All of them belong to one cadre. After regularization of service, they belong to junior SCS cadre. By virtue of that repeal rules, 2022 rules, now a discrimination has been caused. Discrimination is, my lord has seen that 2022 rules. Discrimination is, according to me, subject to your lordship's acceptance. My lord, from the day one, their service will be regularized. They will get 6 annual increments, notional increments. They will get the benefit of seniority. They will get the benefit of promotion. Everything has been spelled out in that 2022 repeal rules. But so far as these contractual teachers who were appointed prior to 2013, although they belong to the same class and by facing due process of selection, they were recruited. My lord, for them, such benefit has not been extended. My lord, I am just placing the cadre rules of 1993 because after regularization of service, they will be included in one cadre, that is junior SCS cadre. My lord, may kindly see the education manual, page 585. The nomenclature of that rules is page 585. The nomenclature of that rules is the Odisha subordinate. My lord, 593. The Odisha subordinate education method of recruitment and conditions of service rules 1993. This is the statutory rules which will govern after their regularization. My lord, may kindly come to rule 3.
cadre of post in subordinate offices. Rule 3.1. The service shall comprise of two grades, namely junior grade and senior grade. Then sub-rule 2. The junior grade of the service shall consist of the following categories of post, namely a headmaster / headmistress of government upper primary schools. B. Assistant teachers of high schools. We are concerned with assistant teachers of high schools. They belong to junior grade of the service. My lord, now your lordship may kindly come. How seniority will be maintained? That is rule 18. Page 600. Sorry, page rule 27, page 602. Determination of seniority. The seniority, my lord, got it. The seniority inter se of persons appointed to the junior grade of the service, both by way of direct recruitment and by promotion in a year, shall be determined in the order in which their names appeared in the list prepared by the committee in pursuance of rules 14 and 15 respectively, provided that the persons appointed by promotion in a particular year shall en bloc rank above those appointed by direct recruitment in that year. Then proviso is there, provided further that inter se seniority of the persons included in the service by way of merger of other equivalent cadre of taken over high schools shall be determined by taking into account the deemed date of appointment of the persons of taken over high schools, vis-a-vis the date of appointment of the directly recruited trained graduate teachers under subclause 1 of clause A of rule 4. Then the deemed date of appointment that has been explained under the explanation. Then your lordship may kindly come to sub-rule 3. The seniority inter se of persons, this is important. Seniority inter se of persons appointed to the senior grade of the service shall be determined with reference to their position in the list prepared in pursuance of sub-rule 4 of rule 18. My lord, so my submission before your lordship is, by virtue of 2022 rules, the benefits which has been conferred on the initial appointees who were appointed after 2013 rules came into force, since those benefits have not been extended to the post pre-2013 appointees, virtually they will be treated junior to a person who has been appointed earlier. And so far as promotional benefit is.
How do you make this submission? How are they going to be treated?
Well, your lordship may kindly see 2022 rules, repeal rules.
What is that?
Repeal rules, my lord may kindly.
So is this your submission? That they will be treated junior because of this?
Yes.
My learned point is covering that group 2011 to 2016. There are three groups, as I said to my loss. Persons appointed prior to 2011, appointed between 2011 to 2013. Under new rules,
from the day one, they will be regularized.
They have taken one date, 4/4/2016,
yes,
as the date of their counting of seniority, so far as the second group are concerned. So the person who is appointed in 2011 will be counted regular from 4/4/16, and a person appointed in 2013 also will be counted regular from 2016. So in that process, the 11-year employee becomes junior too, or he is losing his seniority.
No, losing. Who becomes junior to a person?
Losing seniority.
Huh?
Losing seniority.
Seniority. He does not lose seniority. He may be losing years.
Yeah, exactly.
Not the seniority.
That's the whole submission.
I got confused because of this submission.
Right, not right.
The difference between seniority and losing.
Absolutely.
Please.
Yes. Well, then so far as promotional prospect is concerned, that is also being hindered, because the persons who are appointed subsequently, they will get promotion earlier.
See, if today a person is appointed,
my lord,
against a post,
yes,
having pay scale of 20,000,
my lord,
all right, and whatever. But the same post was there 10 years before. And for that, the pay was 3,000.
Yes.
Can you take a plea that this person has been appointed recently, he has been from day one getting 20,000, and I have been receiving 3,000 from that date, and no care has been taken for us. We should have been given something more than the persons appointed today. And today a decision can be taken that those appointed long back in 2003, they shall also be given the same scale, 20,000. So will that be discriminatory?
My lord, what my lord has said, that is correct. But my submission before your lordships is, my lord, the benefit which has been extended by virtue of 2022 repeal rules, that has not been extended. And secondly, my lord, by virtue
See, if you want to add something
yes,
to what has already been submitted, it's all right.
My lord, I will cite some decisions. So far as discrimination is concerned, your lordship may kindly see. Because they belong to the same class. They belong to the same class, and ultimately after regularization of service, they will be included in one cadre. And all benefits will be, my lord, all benefits will flow from 1993 rules. My lord, may kindly see the decision of Sri Lalita first. My lord, may see paragraph 26 of that judgment.
Yes.
Service jurisprudence evolved by this court from time to time postulates that all persons similarly situated should be treated similarly. Only because one person has approached the court, that would not mean.
Why are you making this submission? Please don't waste court's time.
Then, my lord, so far as the virus is concerned, my lord, I have brought a decision, that is Independent Thought versus Union of India. My lord, may kindly see this. Where discrimination is caused, either that can be struck down or it can be read down. My lord, may kindly come to paragraphs 165.
Mr. Counsel, that question will arise after the court reaches a conclusion that there has been discrimination.
Yes.
All right.
Yes.
So if you are satisfied that discrimination has been caused, stop it. Stop your argument. We will consider.
Yes. And
right. Conclude your argument.
My third plank is, my lord, my third plank of submission before your lordships is, my lord, in some cases by the single bench, it has been held that those who were appointed prior to 2013 for the purpose of regularization of services, their services, my lord, they have to take recourse to 2013 rules. My lord, I have brought some judgments, single bench judgment, which has been upheld in the writ appeal and also in the Supreme Court.
We will follow that if that is required.
Yes. My lord, may kindly see this. Because their government stand was that since they were appointed prior to 2013, so 2013 contractual appointment rules will not be applicable. But this honorable court has held that 2013 rules will be applicable. They will get the benefit under the 2013 rules. And in fact, those judgments have been upheld by the division bench and also in the Supreme Court. Well, two judgments are there. One in the case of Sagarilal Murmu and one Akshay Kumar Mahanti. And the division bench orders are also there, where writ appeals have been dismissed. Writ appeals. This is my argument. Let them give reply.
Lord, I may be, pardon me, Lord, if your lordship would permit me. Only one thing I may add, Lord, your lordship may kindly have a glance to annexure 10 of my brief. This rule 4. It's number. Lord, this is WPC number 36039 of 2023. Only one thing I will add, that is how it is discriminatory. The rule 4, if your lordship is looking at the rule, then I may place it.
Yes.
Let this special provision under the heading, the initial appointees appointed under the contractual rules, mirrored at page 133, you will not support by.
Yes.
The initial appointees appointed under the contractual rules now in positions shall be deemed to have been appointed against the post on regular basis as on the date of commencement of these rules. Now, this is very important. They basically what they intend to do, all those teachers who came to be appointed following the contractual rules of 13 and 14, so they would be regularized after completion of 6 years of service. But here under the 2022 repeal rule, they say initial appointing has been defined. You will have already seen it. So they say that the appointments made under the 13 and 14 contractual rules. From the by virtue of this special provision, they confer the benefit of a regular recruit from the date of their initial appointment. Suppose I am giving an example. Following the 13 or 14 rule, even a teacher who came to be appointed in 21, that is prior 1 year prior or whatever it may be, or he would be deemed to be regular from the date of their his appointment, initial appointment. Which, even if this 6-year formula doesn't apply, they say that anybody whosoever has been appointed following the 13 and 14 rules, they would be deemed to be by virtue of this fiction, legal fiction.
If Mr. Acharya, there is yet another aspect of the matter. So you want that the restriction which applies to you should apply to them also. Like you had to complete 6 years. Therefore, that should be applied to them also. They should also complete 6 years for regularization.
Right.
This is your submission.
No, not exactly like
Why
that.
not? Why not? If that is your submission, then had there been any provision in the repeal act or whatever rules, then you would have been satisfied that all right, it is the provision that they should also spend at least 6 years for becoming regular. Then they will have to be noticed, all of them.
This is by virtue of this rule, that number nobody knows. They want to cut down our benefit. Suppose everybody would have been regularized in number.
See, you are seeking equality. So this is how also the equality can be achieved.
That's correct. Equality basically how they have infringed, that is this point by virtue of the standard operating procedure, which your lordship were apprised of on the last occasion. Your lordship would find it at page 147 million.
Yes. Anything?
149 million. Only one thing this petition they have given. They have made 3 categories here. One group, as Mr. Roth and my learned friend submitted, that the teachers who came to be this initial appointed, they say, came to be appointed, page 149 million.
Yes.
Here there is 149. For those teachers, initial appointees joined in accordance with the Odisha Group B Post Contractual so-and-so Rules 13, Group C Post Contractual Rules Amendment Rules 13, along with this Department Resolution number so-and-so dated 27/10/14, the contractual stroke initial appointee teachers shall be allowed fixation of their pay as on the date of 17/10/2022 calculated notionally from the date of their joining by virtue of granting increments on completion of each year of service under normal circumstances. Illustration A clarifies. That means, suppose a person who has joined after post 2013 between 2022, this commencement of these rules, from the respective date of his appointment, irrespective of the fact whether they have completed 6 years or not, they would be regularized. Suppose we belong to that category of teachers, those who have been appointed between 2003 to 2012, prior to the commencement of years. So 13 and 14 rule also contractual rule, they also postulate the same provision, six years of service and regularization. Now by virtue of the special provision which they made in the 2022 rule, mirrored by giving them seniority, pay, everything from the date of even after completion of 1 year of service or maybe less than that. A 2022 appointee would also be regularized from 2022.
Acharya, your submission is focused on the reliefs which have been granted to the persons appointed 1 year or something before the repeal came into force.
Right.
More against them, less against your favor.
More in their
agreeing-
favor.
No, your submission, you are challenging the privileges which have been given to them more than your.
You're interested. That means interest.
All right. Yes.
Now, this is exactly what they have illustrated in this SOP.
We will see.
Regularization of LOC, SOP Millard at page 149. So Millard, we are covered this Millard, this group B, your lordship kindness.
All right.
Date of risk, teachers shall be Mr.
All right.
Rock
Let us have the view of the other side also. The petitioners have made their submissions. Now we had to required we can. Hear you in reply. Let us see.
May I please, Lord? Let's see their prayer first.
Which case?
That 9791 of 2023.
Nine seven nine one.
931.
Yes.
Married man, issue rule Nisik calling upon the opposite party to show court to why the rule 4 of Odisha Group B, C and Group D post repeal and special provisions rule 2022 shall not be declared ultra virus.
Yes.
This is the challenge, the rule, the virus of this rule is challenged. So the question arises for consideration before my lords, whether they are governed, whether the prayer for quashing are they affected if this rule is repealed. Second, whether they are covered under 2000, they stand on the same footing with the 2013 recruitage as per 2013 rule. As per my lord's direction, I have prepared all the instructions issued from time to time regulating their appointment and the resolutions. It's but second. They. Entire opinion.
Yes.
My lord, your lordship, first resolution of the 2003. That is at page 1 of my today's compilation. Lordship got it. This is the resolution dated 4/11/2003. This resolution was issued for appointment of contractual teachers. I will draw my lord's notice to page 2. Your Lordship may see the page 2,
Yes.
that is emoluments.
Yes.
Why I am showing these provisions, my lord, I want to establish these employees are different from the employees who are recruited in accordance with 2013 rules. That I want to demonstrate this, my lord.
No, there is no dispute about that.
My-
Neither 2013 nor 2022 deal with their initial.
Yes, ma'am. Yes, ma'am. That I want to, why I am demonstrating and what is their nature of appointment and what was their condition of service at the time of their appointment. Let's say that emoluments. The trained graduate teachers, arts and science and classical teachers shall be paid rupees 2,500 and 1,500 respectively per month as consolidated remuneration. Then, my lord, then turn to next resolution of 2005.
Yes. Page
My lord, it starts from page 5.
Page 7. You are referring to page 7.
Yes, my lord. That is clause 4 and 5. The trained graduate teachers shall be paid rupees 2,500 and Urdu teachers, TM and PTs shall be paid rupees 1,500 per month as a consolidated remuneration. Other conditions, my lord, while making contract, then my lord, the contract will be valid up to the end of February from the date of engagement and can be terminated if she violates the conditions of the contract or is found unsuitable later on by the authority without assigning any reason prior notice. While making contract engage, the engagement order must make it very clear that the engagement is valid up to the end of February of financial year and the renewal of contract engagement can be considered only if the continuance of the post is extended with concurrence of the finance department and subject to satisfactory performance to be evaluated by the appropriate authority. And that selection procedure that has been mentioned in these two resolutions, those who are appointed in accordance with 2003 and 2005, there is no provision for regularization of their service. For the first time, the government came with a resolution in the year 2008. I have annexed page 11, you will see that the resolution dated 8/12/2008.
Yes, page.
Well, page 11, my lord. My regularization with 3 conditions, you will also see that 1, 2, 3. First condition, the contractual teachers so engaged will be regularized in their respective post only after completion of minimum 6 years of continuous and satisfactory engagement. That 2 is important. After regularization, they will be eligible for all service benefits as applicable and admissible to regular government employees of the state. On the basis of this resolution, those who are appointed in accordance with 2003 and 2005 resolution, their services were regularized. And with the terms and conditions, they will get the benefit from the date when they were regularized. And accordingly, when they were regularized, they have been extended that benefit from the date of their regularization. Then, my yellow.
Yes.
My next resolution of 25/7/2011, because many appointments are made in between 2008 to 2011. The last appointment on contractual basis was made on 4th. Page 30. Note down what date, my lord.
Yes.
Last appointment on contractual basis in accordance with 2003 and 2005 resolution was made on 4/4/2010. Why I am submitting that has some relevance, my lord. Then your lordship may see 25/7/2011 resolution.
Yes.
That it starts from page 13. Those who were appointed till 2010 after 2008, this resolution regulates their regularization. Your lordship may see clause 3 of that resolution.
Yes.
The government, after careful consideration, have been pleased to decide that regulation of the service of contract teachers in government high schools shall be considered only on fulfillment of the following terms and conditions. Eligibility for regularization. The contract teachers must have rendered at least 6 years of continuous and satisfactory service. Only those contract teachers who have been recruited in conformity with the prescribed recruitment with due adherence to the relevant provisions of ORB Act in Post and Services for Scheduled Caste and 1975. Then, my lord, your lordship say clause 5. The clause 3, the eligibility, clause 5. Creation of post of regularization of contract teachers. After identification of the contract teachers eligible for regularization in accordance with the norms set out at para 4 above, contractual posts held by the appointees shall be abolished and equivalent number of equal regular posts shall be created so that overall sanction strength of teachers remain unchanged. So only after creation of the post they will be regularized. Then, my lord, your lordship, then very important, my lord, 7.
Yes.
The date of appointment in regular establishment shall be reckoned at the first appointment to the service with regard to all service benefits.
Yes.
My lord, then 8. Consequent to the observation of such teachers, they shall be governed in accordance with the relevant acts and rules and instructions as are issued by the government from time to time in this connection. So from the date of regularization, they are governed under that service CCA rules and the rules they are mentioning that education, the rules mention that education manual. So they, from the date when they are regularized, all the rules are, they are binding by those rules. In accordance with these instructions, their services were regularized. Then, my lord, I'll again bring to my lord's notice the next resolution of the school and mass education, that 27/10/2014. At page 17, my lord. This resolution was passed after 2013 rule. And there is a provision in this resolution, page 21, clause 6 of that resolution.
Yes.
The emoluments and service conditions shall be guided as per the provisions of GA Department Notification number 32010 General dated 12/11/2013 and number 1147 General dated 17/1/2014 read with notification number 4587 General dated 15/2/2014 for Group C D employee. These notifications are related to the contractual appointment rules of Group C, Group D and Group B. For the first time, this resolution in 27/10/2014 governs in accordance with 2013-14 rules. So all the appointments made after this 27/10 in accordance with 27/10/2014, they were governed in accordance with 2013 rules. All the appointments made prior to 2014, the last appointment by that is 4/4/2010.
Yes.
They were appointed on contractual basis in accordance with the resolution of 2003 and 5. They have been regularized in accordance with the resolution of 2008 and 2011.
Yes.
And then I'll bring my lord's notice that 2013 rule. But before that, I'll again bring to my lord's notice one resolution of that government matter that is at phase 30. That is regarding regularization of contractual employees.
Page 13,
30 mile 30
30.
mile. Government NG and PG General Administration Department issued a resolution regulating the regularization of contractual employees, Group C and Group D contractual employees who were appointed prior to 2013 rules. Let's me see clause 1. A gradation list of such contractors shall be prepared by the appointing authority on the basis of the date of appointment. In case the dates of appointment of 2 or more employees are the same, their interposition may be decided on the basis of the date of birth, taking the elder as senior. Then, my lord, regular appointment of the above categories of contractual employees shall be made on the date of completion of 6 years of service or from the date of publication of the resolution, whichever is later. This is regarding regulation of the date was given, that is, that date is 17 September 2013. Irrespective of the fact they have completed more than 6 years, as on 17/9/2013, they will be regulated with effect from 17/9/2013. This is regarding that contractual employees who are not appointed under contractual rules, my lord. This is regarding Group C and Group D. And another regulation was also issued by the GA department by LRC at page 34. That is regarding Group B post. That was issued on 15/2/2014 at page 34, my lord. LRC page 35. Same provision. Irrespective of their continuance, on completion of 6 years, they will be regularized, but the date is 15/2/2014 in respect of Group B. In respect of Group C and Group D, that was 17/9/2013. Then I'll bring my lord's notice to page 38, the contractual appointment rules to 2013.
Yes.
LRC see, there is clause rule 4.
Where is that?
Rule page 40, my lord, 40, my lord.
Page 40. Just.
Rule starts from page 38. I am bringing my lord's notice page 40. Rule 4. For the purpose of these rules, all contractual appointments made prior to the commencement of these rules shall be classified into 2 categories, namely, Category 1, contractual appointment engagement made against contractual post created with the concurrence of the finance department without following the recruitment procedure, including the Odisha reserves, vacancies in post and services for Scheduled Caste, Scheduled Tribes Act, and the rules made thereunder, and the rules regulating the recruitment for the regular post. Category 2, a contractual engagement made through service provider agent with the concurrence of the finance department. Why I am doing my lord's notice, what benefit has been provided in these rules for this existing contractual employees? That you will see rule 8. The contractual employees belonging to category 1 and the persons provided by the provided agent under category 2 who shall be less than 45 years of age and shall have completed at least 1 year of continuous service in case they apply for recruitment under sub-rule 1 of Rule 5 for any Group C and Group D post shall be allowed relaxation in upper age limit for entry into government service, provided they satisfy all other eligibility criteria for the post as laid down in the relevant recruitment rules. They shall be allowed 1% extra marks in the total marks of the examination for each completed year of continuous service, subject to a maximum 15%, which shall be added to the marks secured by them for deciding the merit position. This benefit was extended in respect of existing contractual employees. But so far as those who are appointed in accordance with these rules in Rule 5 of this rule, what benefit they have? The you'll also see Rule 6. Before that, you'll also see Rule 5. Recruitment to the post shall be made on the basis of the provision of the relevant recruitment rules or executive instruction as the case may be enforced. Notwithstanding anything contained in the relevant recruitment rules or executive instruction as the case may be enforced, all appointment made pursuant to sub-rule 1 shall from the date of commencement of these rules be on contract basis. Rule 6. Status of for the purpose of contractual appointments made under sub-rule 2 of Rule 5, all vacancies existing on the date of commencement of these rules as well as future vacancies shall be deemed to have been converted to contract from the date of commencement of these rules, provided that consequent upon regular appointment under sub-rule 1 of Rule 10, the contractual post shall get reconverted to regular sanction. What I mean to say, my lord, here, my lord, when an is appointed under these rules with a condition on completion of 6 years, he is to be regularized. And the post is there. Post is not abolished.
No, it says for the purpose of contractual appointments made under sub-rule 2 of Rule 5.
Well, all vacancies means all existing vacancies of regular vacancies. On the date of commencement as a future shall be deemed to have been converted to contractual post from the date of commencement of these rules. Provided consequent upon regular appointment under sub-rule 1 of Rule 10, the contract shall get converted to regular. What Rule 10 says, you'll also is Rule 10.
Oh, you just understand 5 and 6.
Well,
5 says recruitment to the post shall be made on the basis of provisions of relevant recruitment rules or executing the instructions as the case may be enforced.
well,
So it simply says recruitment under 2013.
yes, under 2013. That I want to say.
All right.
And there is a post, the regular post is converted to contractual. The appointment will be made on contractual basis. On completion of 6 years, again the post will be reconverted to regular post.
No, where is that 6 years?
Yes, I am calling that Rule 9.
So Rule 6 has the only consequence of all the posts
Yes.
which are vacant. All right.
Yes, ma'am.
Are to be treated into
Contractual.
contractual.
Yes,
posts.
yes, ma'am.
So that is the consequence of
Yes, rules. That is the Rule 6. So
That is the
post
Rule 6.
exists.
posts exist vacant.
Post exists vacant.
Vacant existing posts stood converted into
Contractual.
contractual posts.
My lord.
Yes,
And it is only converted to regular post on completion of 6 years.
that is.
Yes, mention 9, Rule 9. Nine one, tenure of contractual appointment. Persons appointed under sub-rule 2 of Rule 5 against the contract shall continue on contractual basis for a period of 6 years. The period of 6 years shall be counted from the date of their contractual appointment under Rule 5. Then you'll also may turn to Rule 9.
Yes.
You'll also Rule 10. on the date of satisfactory completion of 6 years of contractual service under sub-rule 1 of Rule 9, they shall be deemed to have been regularly appointed.
Yes.
A formal order of regular appointment shall be issued by the appointing authority. This is the basic difference. Those who are appointed prior to 2013 and those who are appointed in accordance with the contractual rules. In contractual rules, there is a condition before their appointment, at the time of their appointment, they will be regularized on completion of 6 years of service. And there is a post which will be converted to regular post on their completion of 6 years of service. But the petitioners who were up before my lords, when they were appointed, there was no condition precedent for regularization of their service. Only after, sorry.
See, on the date when 2013 rules came into force, there was no contractual teacher whose service was not regularized. There were teachers who were appointed in 2010.
Well,
the last person.
Last person for 2010, my lord.
2010. So they were yet to be regularized.
Yes.
Otherwise, all others were already.
All others are regularized.
Under the earlier previous scheme. All right, then.
Yeah, so
this is the distinction.
This is the distinction. So I want to demonstrate that they are not covered under 2013 rule and they cannot take the benefit of 2013 rule.
No, they are not claiming.
Now that I am coming. What they are, I have seen their plan and I have heard their submission and their entire submission to cover them under 2022 repeal rules. Though they have challenged the high risk, what is their prayer before my lords? They want to get the benefit which has been extended to others in accordance with 2022 repeal rules. In one hand, they are challenging the high risk. In other hand, they are making a prayer before my lords.
They are making a prayer. They are saying that if you apply that to them also,
Yes.
then there is no problem.
No, that
you don't apply, then there is a discrimination. This is what they are.
Yes,
right.
yes, ma'am. Those who are appointed at the last contractual appointment are made on 4/4/2010 only because by that repeal rules, seniority was conferred from the date of their contractual appointment by those who are appointed in 2013. Only to protect the interest, those who are appointed on last appointment was 4/4/2010. The SOP was issued and that last resolution was issued protecting their seniority. Protecting their seniority, in accordance with 2014 rule, first appointment was made in 2016. So those who are appointed in 4/4/2016, their seniority was protected. Only to protect their seniority. The last protection is that.
No, your submission is that the persons appointed prior to 2013, not in accordance with 2013 rules, in their cases, there was not certainty
Yes.
that their services shall be regularized.
Yes, that is my entire service.
Whereas those who were seeking employment under 2013 rules, they were certain that their services shall be regularized.
Yes. And why they cannot get the benefit why they cannot get the benefit, and I have drawn my lord's notice that resolutions exist which post they were appointed. And when one can get the benefit. Your lords may see Rule 36 of the Odisha Service Code. Rule 36.
Yes, what is that?
Permanent post. Permanent post means a post carrying a definite rate of pay and sanctioned without limit of time. So the one is entitled to all the benefits from the date when he holds a permanent post. I've shown, my lords, on creation of a regular post, they were regularized. From the date of regularization, as it evident from the resolutions, they will get all the service benefits. As the post was created after completion of 6 years, they are entitled to all the benefits attached to the post. When the post was not there, they cannot get the benefit which is attached to that post. As 2011 resolution says, on creation of the post, they will be regularized. So they are entitled to get the benefit from the post, they are regularized, not prior to that.
Yes.
And another aspect, my lord, they have never questioned their regularization. When they regularized in 2011, 2008, they have never questioned.
Yes.
And after 14 years of regularization, they are before my lords to get the benefit, all the benefits from the date of their initial appointment.
Yes.
And your lordship, I'll bring another point, my lord, your lordship, that 2011 resolution, one aspect only. Yeah, Lordship, I say page 15, that 2011 resolution. Clause 9, my lord, of that resolution. It's page 15, my lord, 15.
Yes.
The pensionary benefits admissible to the state government servants under the newly restructured defined contribution scheme as per the amended provisions for the Odisha Civil Service Pension Rules 1992 Finance Department Notification 17/9 shall be applicable to these teachers. Why I am showing these facts, my lord? As they were regular, they are appointed, admitted fact, they are appointed in 2007, 2008, and 2005, prior to 2005. But regularized after 2008, regularized after 2005. So as they were regularized after 2005, they are brought to the fold of new pension scheme. And now they are the members of the new pension scheme, not under the old pension scheme. Now, in other words, they are claiming the benefit of old pension if their service will be reckoned from the date of their appointment. Then we brought to the fold of old pension scheme. And when they are regularized in accordance with one resolution, and that resolution is not under challenge, and they have not challenged, the modalities has been formulated in that resolution, how their service is to be regularized. And after regulation in accordance with the resolution, they cannot divert their claim beyond the scope of that resolution. And I have shown, my lord, that since they are not covered under 2013 rule, they cannot take the advantage of the repeal 2022 repeal rules. This is my assumption. And I have prepared the short note.
My lords, give us a day time, 1 day time to
At least
come back before my lords with his reply to my learned friend's submission. 1 day time.
Because we also,
Because
your lordship also posed certain questions. My learned friend has given some answers. We want very composite answer to that.
so there will be uniformity in our reply.
State. I have requested on behalf of the petitioners this matter on Thursday. Or
That will do.
Coming Thursday. Another matter your lordship has fixed to Thursday.
it will not take much time.
My lord.
They have to answer.
My lord.
reply to this submission. It was from behalf of the estate.
Yesterday 2 PM. man.
2 p.m.
So,
We taken a better.
Orders item number 21.
Last occasion issued notice on the question of limitation. Job contract employees claiming regularization of their entire period of service for pensionary benefits.
When is that matter is coming when? July something?
After disposal of SLB.
After disposal of the SSSB.
Yesterday, item number 26.
Okay. Yesterday's item 22 and 26.
26 WA 113 2024. 113 2024. My lord.
And WA 194 of 2023. 94 of 2023.
Only also 2023.
113 is of 23 or 24?
24.
This along with connected matter, IBA 113, 2024, that after disposal of SLP number.
I am appearing for respondent number 1, my lord. In sub item also, I am appearing respondent. I'm filing my just now, my sub item.
Filing the registry.
My lord.
Then Mr.
Pick him up, my lord.
Here the instructions to appear on behalf of the respondent number 1. Shall file wakalat nama in course of the day. But the same order. This is it.
Item 22.
Didn't?
Here the notice has been made sufficient. Item 22. My senior Mr. Putia was.
What is the delay?
22. Kitte din delay also.
It seems to be.
I deliver. On 6/7/87. 22.
Second report indicates the item delivered, this has been delivered on this appears on 13/7/2024. This is the executive member and council and appears on behalf of the respondent.
Item 22.
Item 22, my lord, your lordship is
Waiting solution.
So here, it says that addressing is more. Question typing the question addressing is
Move.
23.
22.
22.
22 it is. 22.
22 already.
27 of 24.
Yes, ma'am.
The delivered.
23.
Not delivered, addressing more.
23, there are three matters. In first matter, not delivered, addressee.
Second, third delivered.
Next two items already delivered.
That is 2 days. 2 days 16.
Then same order as item 20. And the second and third sub item. First item let us post to that day and see if anybody is appearing. Because the AD and that postal is not back.
Not bad. But it has, but it is indicated not delivered, addressee moved. Fresh steps has to take. So 2 weeks time.
Postal tracking, the first sub item. Postal tracking report indicates that like the notice has not been delivered as the addressee is moved. Against AD and answer notice have not returned from the respondent number 1. Mr. Saswat Das, the advocate, placed for 2 weeks time to take fresh steps of service of limitation notice on the respondent number 1. If visits are filed and undertaken within 2 weeks, notice shall be issued. Notice shall be issued with the returnable date of 4 weeks, just after 6 weeks.
Item 24.
Item 24, here the postal tracking report is item bagged. Must have been served in the meantime.
Waiting. Since the postal tracking the report indicates item back, neither AD nor answer notice are back from respondent number 1. This is the case on this is the case on 30/7/2024. Meanwhile, the up-to-date postal tracking report shall be back with the case record.
There are two other sub items. The second sub item, delivered.
Two days.
Second item. The third sub item, the item back. So,
Item number 25.
Also, Utkal University before my lords, that is matter concerning regularization of service forming a scheme. In one matter, there is a delay. In all cases, there is a delay, 5 cases altogether. One matter, my lords was pleased to consider the matter on merit and condone the delay, my lords. Their my lords directed.
How much delay?
228 days delay. Here, my lord, 233 days delay. There, my lord, 228 days.
One matter already delay condoned.
So there,
Yes, my lord.
when is it posted?
That was posted as last week.
Last
Thereafter, no date has been fixed. Number, my lords, I'm giving.
2267 of 23.
6/7.
That is the
Yes,
order, ma'am.
Last time it was listed but could not reach.
20,000.
Same order 20,000. This along with May 11/7. Okay. So list the case on within 2 weeks.
Minutes.
1 month. In 3 weeks.
Yes.
Cost will eventually or till.
Minutes will pay within minutes directed within 1 month.
Same, list on 4 weeks के beginning.
13th August.
No, packet. 13th August, that is 4 weeks. Or what? It's the case on 38, 38, 2024. That all the cases. One is left out, other three are listed together. That is not.
Item 26.
Mr. Kanungo is on his legs from the old court. He is just on his way, my lord. Just one pass over, I pray, my lord. He's just on his way. Yes, my lord. Notice was sufficient. Yes, my lord. Yes. Deeply obliged. Deeply obliged.
Item 27.
And 27, notice on limitation is issued on 1/5/2024. What is the play? At 300 days. This is matter regarding that Sartapadi pension of block grant employees. Clerkship has issued notice in similar matters.
Any idea when the connected managers are posted?
Yes, ma'am, that.
The last one. Thereafter, we check on.
$10,000.
This COVID period will not cover because this is 20.
No, ma'am, because it is disposed upon 2/11/2022, filed on 2/12/2022. Exactly 360 days delay. 366. Because 1 year, 2/11 to 2.
Reduce the applications. Although we are not satisfied with the explanation for the explanation for the delay, finally, but in the express for justice, we are inclined to follow the delay. Along the delay, subject to the rupees 10,000. High Court Bar Association Advocates Welfare
Well,
within a period of 4 weeks.
4 weeks.
Village owner to the is accordingly allowed in the case for fresh admission.
20th August. 20. Item 28. Lordship, I am for the sole respondent. I seek some 1 week time, Lordship, for better
So
preparation.
you are the only person who will serve the sentence. You are the only person who will be serving the sentence. It's a contempt matter, no?
No.
It's a
Read appeal.
Read appeal only.
He seeks some time. I am for the appellant.
only
Adjustment.
But have you appeared on behalf of the
appeared when, Lordship, I have appeared on 12th of this month. Lordship, I have the receipt. But this has not,
other matters, 4, 5 other matters, or this is only matter?
this is only matter. Lordship.
Only.
1 week, Lordship. 1 week.
Mr.
Origin.
Well, 7/2024. Praise for 1 week's time to file it. 1 more week. You taken time earlier? Have you taken time earlier to file?
No. Objection he has filed.
Objection already filed.
Matter was yesterday.
Yesterday was matter. Yes, Lordship, I have the receipt object has filed, but it has not come on the record.
Filed it yesterday.
12th of June, Friday, 12th of July.
Five. Objection.
Yes.
Either the Wakalatma one or the objection are there on record. This is the case on 23/7/2024. When this is ensure that the objection to the IA is scanned and incorporated in the digital record in the name of Mr. and the council is reflected in the college.
May I please, Lordship? 23, 22nd, 23, I have personal difficulties. 24th, Lordship. Item 29.
I am for respondent.
Delay of 415 days. Last occasion, your Lordship, please to issue notice on the question of limitation. Copies were
Give him
served.
some money. How much money will you take for condonation or delay?
My lord. What amount, my lord?
Maximum?
I have no expectation, my lord. What amount, my lord, passed?
What is there any merit in the?
Merit that the read petition disposed of in terms of Malayananda city. The date of death is 2003. No diligence shown by the petitioner. Although there was some slow approach by the state authorities in considering his application. No diligence shown by the petitioner from approaching this honorable court. Only in 2022 he approached the honorable court and the honorable court directed to consider his application in terms of Malayananda.
20,000. 20,000.
Great applause.
Granted.
With the explanation, in the interest of justice, we are inclined to prolong the delay in filing the certificate subject to payment of cost of ₹20,000. This is installment number one within a period of 4 weeks. This is the case of subject for 28 here in August 2004 of that. Have you received a copy of the appeal?
Item number 30.
Please. That 14 days in delay, my lord. My lord.
What is this case?
No, is relating to appointment of by petitioner by manipulation of record and which was challenged. And judgment was passed on Annexure 7 running page 116. Before that, there is a judgment of state is no terminal directed to for inquiry by open number 2, Director Higher Education.
Yeah.
Question of condemnation of delay, notice on behalf of. So, government parties are also there.
Welcome.
We respondent one, we will take notice. Other government will accept notice.
Yes. Well,
Okay. If it is within 1 week, notice to convenient within 4 weeks, let's start to 6 weeks.
Lovely.
Okay. I will. Customer was fine. Why have you made the party visible?
He used the headmaster manipulate record and direction was given that.
So I will identify the customer to the opposite party. Just take it there. Identification of the user. Yes. Yeah. No. Who's there, Mr. Das? Yes.
13th August. For admission item 31.
Lordship, in the present writ petition, the contempt is arising. Lordship deals with Berhampur Development Authority.
No, but we are inclined to hear the writ petition.
Lordship, the writ petition it deals with Berhampur Development Authority. Lordship, earlier it used to it was allotted to division bench, but Your Lordship, according to new allotment, it goes
Yes,
to single bench.
Where
Your
the
Lordship.
order passed under section 91 of the Development Authorities Act. Now the assignment it shall be assigned to a single honorable single bench. But at the time of issuance notice, it was division bench. So if your lordships can hear this matter sometime at the single bench or whatever it is.
It has been stated at the bar that as per the roster, WPC number 12029 of 2011 is to be placed before a learned single judge. So put up this case for appropriate bench as per the resolution.
And 32.
Obliged, Your Lordship.
May I please, my lord? My lord, in this case, pursuant to the affidavit filed by the state opposite parties, your lordship had directed me to file the rejoinder. If your lordship allows, I'll submit it. I have solved the copies on that.
But my friend has just now given
Yes.
this notes, result of switch more than 156 pages.
Even-
I've given
Also,
it. Grant some time, I will go through and file it.
also, my lord, pursuant to lordship's order dated 7/5/2024, the OP number 4 and 6 also have filed one affidavit.
Copy may kindly,
Clarify.
copy may kindly be given to us. Or copy. The Indian number file to us.
Yes.
With your lordship's permission, I would like to place the case.
How can you place that?
Yeah,
That has not
just now I
been
can
specified.
place.
And copies have been served upon us now.
On all the amicus curiae, three of us, my lord, copies have not been served.
I served one copy on my case queries.
And the Union of India also, my lord, is serving a copy right now. So we'll go through it, my lord.
So you can share your pen drive.
Yes, yes.
They'll provide you soft copy. Why?
I'll provide this.
That will be more convenient.
My lord.
Affidavits have been filed on behalf of the student council for the part. File it in the register. File it in the register. Council on behalf of learn amicus curiae and you
The OP number 4 and 6, madam. Union of India.
and OP number.
My lord from the petitioner, not on the case. Affidavit on behalf of the petitioner.
Additional affidavit on behalf of the petitioner and the Union of India.
OP number 4 and 6, madam.
Council for the petitioner and Union of India intend to file counter affidavit, additional affidavits. Let the same be filed in the registry by tomorrow. Also, let soft copies of the affidavit be served upon learned amicus curiae. Also, this matter on 1 week.
I have already served, madam. To the petitioner,
Why
so
has it become so voluminous?
My lord, next week I will clarify it.
No, just we have become curious. Yes.
My lord, to begin with, if I'm allowed to recall what Honorable Justice Talapatra had said while hearing this matter, that this is a PIL matter, there shouldn't be any contestation. But with apologies, I am to say that on this very humanitarian issue, such averments have been taken to deceive and mislead this court, your lordship. Therefore, I had to produce certain documents in support of my prayer, your lordship. That's why it has become voluminous.
And
Health and Family Welfare Department Commissioner cum Secretary
She is also present.
join the proceedings online. But why have you joined, madam?
No, your lordship's direction was there to, she had to be in the VC. Your lordship's the order was there. No.
When?
Not on the last occasion, not on the last
Order was on 2nd of May, Milords. So she has been continuing because there is no order dispensing with.
Appearance of secretary.
2-5 no order dispensing.
Stands dispensed with. For the present.
Required, we will ask for it. All right.
Obliged.
Item number 33.
I'll also call it up 2 weeks, Milord.
1 week. Why?
You want 2 weeks or 1 week?
Because so voluminous, I have to write them, they will reply it again, not my friend. 2 weeks.
Item number 33.
May please your lordship. This is a PIL matter, my lord. Matter relates to installation of fire safety system in the premises of one. My lord, this matter appears today's list, my lord, as per order dated 24th June 2024.
Wrong
As
things
per-
are happening.
They have filed affidavit, my lord, and handed over to me yesterday, my lord. I will go through it and I will file a reply affidavit. The relevant paragraph of the said affidavit is at para 3, at page 1 and 2. The implementing authority has not filed the affidavit. However, I will file a reply affidavit. Some time may be allowed.
Yes.
Yes, that affidavit is filed yesterday, it was brought to a lordship notice. Copy was given to my learned senior. I want to lordship granted somebody, let him file that reply affidavit.
Is it necessary affidavit after affidavit
Because
after?
I don't know, my
Is it
learned
required?
senior wants.
My lord,
Is it required?
it is required, some factual dispute is there.
Dispute we will not.
Not, But I may be permitted to submit, my lord, the affidavit which has been filed by the opposite parties, that the relevant paragraph is at para 3, my lord. I would like to place para 3 of their affidavit.
Whether tender notices have been issued.
Yes, sir, 34 works has already begun, Lord.
Begun,
So we will carry out, Lord, not that process
we
given
can
some.
close the proceeding. Why should we keep it pending?
Some, my lord, due to the
Yes, yesterday only, Lord, it was filed.
So
Yes,
dated, affidavit dated.
dated 12 July, my lord.
12th July, Lord.
12 July, handed over to us
So we
yesterday.
can close the proceedings based on that.
No matter, the matter must be pending due to the interference of this honorable court. The work is progressing, my lord.
We will issue certain directions.
My lord.
And based on whatever has been stated in the additional affidavit, and we shall give you liberty to approach the court if that is required. The matters should not be kept pending like this. And if you have any grievance later, you can come. We are here. All right. It is stated by AG1 that an additional affidavit has been
No, like make the hard
been
copy.
filed on behalf of additional affidavit has been filed online
On 12th of this
12
month.
July.
on
12
12/7/2024, shown by the Director General Fire and Emergency Services, Odisha.
No, but affidavit has been filed by the fire officer, Central Range, Kotak, Lord.
On behalf of.
On behalf of.
Shown by on behalf. Containing the status of progress for the work of installation of firefighting system in all buildings of the SCB Medical College and Hospital, Cuttack. First off, it has been stated that firefighting works of 34 buildings have started. First off, however, such work in 9 other buildings is yet to start. So, it has also been stated that the concerned agency has initiated action for procurement for equipment, and the work shall start within a week and will be completed within the contract period. Stop. The finalization of tender and execution of work for 4 buildings shall be taken up within a week. So it has also been stated that the fire safety work which commenced in respect of 3 buildings, namely New Medicine Department, Ophthalmology Department, and Obstetrics and Gynecology Department, will be functional by 25 July 25/7/2024. Also, a copy of a communication dated 11/7/2024 made by issued from the office of the superintending engineer, Cuttack bracketed R&B, Division number 1, Cuttack, addressed to the Deputy Fire Officer, Cuttack Circle, has been brought on record by way of Annexure A to this said affidavit. Full stop. Next. This writ petition in the nature of public interest litigation was filed in the year
2015.
2015. Various orders have been passed in the case from time to time. A reference may be made to the order dated, orders dated 4/3/2024 and 13/3/2024, which read thus. Full stop. Next. Since pursuant to the orders passed by this court, the opposite parties have taken steps for installation of firefighting system in all the buildings of the SCB as SCB, as is evident from the government Smith in the affidavit filed on 12/7/2024. We dispose of the present rate application with an observation that the opposite parties shall make best endeavor to inform, to ensure that the work of installation of firefighting system in the hospital, which is of immense public importance, is completed within the time stipulated under the contract public work orders. Of this application stands as well. We highly appreciate the sincere effort made by Mr. A. Manthil and senior counsel in taking up this matter of great public interest.
Not senior counsel.
Okay,
I am only counsel.
Counsel.
Counsel for taking up this public interest litigation of great importance for the sport. We equally the effort made by the assistance extended by land council representing the estate also deserves due appreciation.
I'd like to make some submission, my lord, only small submission. The affidavit which has been filed by the opposite party on 15 July, the work which has not been completed, that has been reflected at page 7, my lord.
This is next item.
Wherein it has been stated that some work has not yet been started. That 7 to 8 work has not yet been started. Tender has not been finalized in some of the work. So they have to complete it within
So
a.
therefore, we have mentioned that we
My-
should make best endeavor. Something has started, otherwise nothing was happening
No, my lord, for the interference of your lordship.
because of you.
No, not.
We interfered because of you. Otherwise, had there been nothing before us, we could not have done anything.
In the affidavit, they have stated that they'll try to complete it within that period. In the affidavit, they have stated. So that
But-
also we've,
But in
Okay.
some work, the tender has not yet been finalized,
they have stated that they will
We
do it.
cannot see
my lord.
when the election, during the course of election, we had, this is the case where the Election Commission of India
My lord,
gave special permission
pardon.
for the issuance of tender notices. Tenders are in the process of being finalized. We cannot direct
No,
that you finalize it, you do that.
But-
They're doing it.
But-
If they don't do it,
My
you
lord,
can file a fresh writ application. See, does it not look bad that this matter is pending for last 9 years? So you can come again with,
Just tell-
will exempt all court fee. if you
My
want
lord,
to.
my lord, during the pending.
Listen, tender, if they don't comply with all the conditions, the work will be substandard. So we can't also ask them to do it without that.
During the pendency also, a tragic incident took place. During the pendency of this writ application on 12 June
Yes,
2014, some.
Sir, that's in respect of private, not at SCB Medical College.
No, no,
In
but
the
that
SB
also is a matter of concern.
That is why not now.
No, no, and what I said, they had equipment, but nobody could
Operate it.
operate it.
Right.
Just imagine.
No, in the SB Medical College, tragic
That
incident
had
took
happened
place.
earlier.
And in
Last date you were mentioning.
12 June,
Yes,
the copy of which has been placed before this.
You had-
I am obliged, my lord.
yes.
Item 34.
Item 34, but two matters are there. Lordship may see that the connected matter WPC number 15395. That matter was last listed on
The primary school basic amenities matter. Lordship on 27/6 we are pleased to pass an order to, that format was accepted and directed the state government to comply within 6 weeks. I believe that 6 weeks period is not yet over. So
that was
this matter.
my lord's direction 27/6/2024. It is 6 weeks.
Are you doing something?
My lord,
Something is being done. We will adjourn it.
my lord, no, because it has come yesterday.
You can send a reminder.
Both the matters are different, my lords. The first matter is different from my learned senior.
Yes. So that matter can be segregated.
It had been segregated, in fact. Previously, your lordship had segregated it. Somehow it has come up together.
First is,
First is that with regard to that B.Ed fake certificates, your lordship may recall it, midday meal siphoning of funds and all that. So they had filed an affidavit on the last occasion.
all right. List WPC number 15395 of 2015. Excuse me. So let that come on 8th August. List so and so on 8th August.
Dealing.
Let so and so be delinked from this batch and be listed on your date fixture. Yes,
As regards the first matter, my lords, last occasion on your pursuant to your lordship's direction on 14/7, they had filed an affidavit. If your lordship has that affidavit,
yes.
21/7/2024, that affidavit.
34.
34.
First one.
Lordship has. Your Lordship may come to page 4. Page 4, paragraph 8.
Of your writ petition.
No, my lords, the affidavit they have, the state government has filed, director has filed on the last occasion.
Additional affidavit.
Yes.
Yes, page 4.
Para 8.
Para 4.
They have in fact developed upon the last information they had given to this court. They had stated on the last occasion 385 FIRs had been filed on this instance. They have indicated that 474 established fake certificate cases out of FIR had been lodged against 474 teachers. Out of 474 cases, investigation is going on. Admittedly, my lords, because this is an ongoing process. So periodically they are apprising your lordship through this affidavit that this is the status of the fake ID which has been identified. Now your lordship comes to the next page, para 10. They have now started addressing the other aspect with regard to the midday meal. Para 10, they have indicated. Now, what has happened is at the grassroots level, they don't have these.
No. Are we reading the same page? You are referring to page 5, paragraph 10.
Yes.
Begins with that it submit that honorable court directed to submit.
Yes, my lords. Yes, my lords.
Yes.
So in relation to that, non-existent students for misappropriation of midday meals. What has happened is I found out from the affidavit to assist your lordship. At the grassroots level, they didn't have the information with regard to how many students were there, and because there's a unified system, data system, which the directorate has. Now, what they've done is, by Annexure A, E by 2 series, they have communicated all the data with regard to the different students to the grassroots level, the various districts. Now they have asked upon, if your lordship comes to the Annexure E by 6, which is at page 23, they have called upon the authorities that this is the student database management system, and as per the duplicate student record has been provided under various heads within the state, outside state demography, Aadhaar duplicate and Aadhaar duplicate outside the state wise. And now, since they have given that information to the concerned authorities, I think they'll have to carry out that entire process of how many midday meal fake students were being on the name of fake students, midday meal was being given. So that process, I think they have indicated in their letter that these are the number of students in different districts, and you please kindly find out and inform us. So I think that has to be waited from them until they don't submit that data.
It's the last letter on 27/6/2024.
24, yes, correct.
What are the present status? You'll also may grant some time. I will take after this letter. What is?
That may require some time. But if your lordship sees page 24, that affidavit. They've given the enrollment details.
Page 25 is the last letter,
Last letter is page
28/6/2024.
So there are two aspects, my lords. They are continuously dealing with the process with regard to the
So
fake.
out of 30 districts,
Yes.
which district is dominated by tribal population?
Tribal population.
Malkangiri.
Kandamar, Kalahandi.
From where do you get it?
And by our testimony, yes.
Koraput, Malkanagiri, Mayurbhanj, Nabarangpur. Both.
From where are you reading?
I mean, no, that I am from the list. I am saying that tribal people.
In fact, the state government has formulated Odisha midday meal rules 2016.
No, we are just think, analyzing this data on different lines,
My lords.
like, see, you are saying that this Keonjhar is dominated by the
Tribal.
tribal population. So, and the enrollment, there is 2,21,900. Quite substantial.
Quite substantial.
Coming to school and eating or just?
The percentage data of tribals in these districts has to be formulated, I mean, indicated by the state government. Because they must be having the records, the percentage of tribal population, SC, ST and other backward classes. BCs and others. This is very general information before your lordships.
We understand that.
In fact, I was looking at the Odisha midday meal rules. Under Rule 9, they say that in fact there are two types of sanctioning for midday meals. If I may place the provision, my lords. If the midday meal is not provided in the school on any day due to non-availability of food grains and so, cook come helper or any other reason, the state government shall pay food security allowance. Now there are two aspects. One, there is a sanction is made and the food is given. And the other cases with regard to where allowances are being paid. So those two heads have to be segregated before any affidavit is filed before this court. So in that case, they have to identify where all they have given those allowances and then where, in which instances they have granted the sanction with regard to specific schools in which these foods have been.
Hopefully there is no overlapping. Providing the food also and the allowance.
That.
So we should wait for what information?
Perhaps if your lordship sees the last page of that affidavit, page 25.
23 count.
25, they have short, in fact.
23 tablet.
23.
23 ରେ ଦେଖନ୍ତୁ ଯୋଉଟାରେ ହଉଛି elimination process
They have asked them to verify these records individually district wise.
No, just see what is the communication.
Page
23 starts.
Prior to that, you'll also see page 22. Inviting a kind to the above said, sir, in order of the Honorable Chief Justice, the aforementioned WPC PIL number filed by Sanjay Kumar Maharana versus State of Odisha, it is to intimate that the Honorable Chief Justice directed to the undersigned to file an affidavit regarding non-existent of.
No, you are reading which paper?
Page 22, my lord.
22.
My lord. This was addressed to the State Nodal Officer Midday Meal Program Bhubaneswar by the Director, my lord. Director Elementary Education.
Well, see what is the
Yes.
response.
Yes, you got it.
Huh? You read it. Page 23. 23 is the reply.
Yes, my lord. That
23
page 23 is the reply of the Nodal Officer.
Yes.
In this regard, I am to state that there is no such database of existent students in UDSC plus Student Database Management System SDSM 2023-24 ongoing. A provision of duplicate student record has been provided to search the duplicate students under the following for verification and elimination in future. These are the data. This is for your kind. Thereafter, the list is given. The year-wise students.
Each district.
Each district. Then page 25, my lord. Supply of data relating to average number able midday meal. In continuation to this office letter number so and so, I am to enclose here with the
You are reading
information.
which page?
My page 25, my lord. That is letter data 28/6/2024 issued by State Nodal Officer. My
No, but nothing is being done to identify
yes, my that
those
yes, my only they have given a
the ghosts.
yes, my lord. They only they have given a figure. Your lordship can turn to page 26. If your lordship that is the figure they have given. Your lordship the year-wise figure. In so I am giving an example of Honorable District. PAV approved children 1,20,456. Then while number of children availed MDM.
What is PAV?
Project approved. They've used it. Project approval board. That's a board constituted by the Department of School and Mass Education.
No, but see, you may take a stand that there is no non-existent.
Yes, there your lordship has seen that.
Or you don't have any idea.
Yes, my lord.
Or you cannot identify.
Yes, my lord.
Or you have attempted to identify, but you have failed. But there is nothing.
Yes, yeah, but as it appears, the number of children approved children and number of children availed MDM.
That is less.
That is less.
Less than approved.
Yes, less than approved.
So therefore, your stand can be there. There is no non-existent.
So yes, but so for my lord's query is that affidavit are not satisfied.
Your affidavit.
This
Your affidavit does not satisfy.
my lord's query that because this is a common affidavit, this is a common data that has been provided. These are the approved and these are availing. So admitted fact, those who are not availing, so these are a non-existent. The less are availing midday meal. Let's can get that figure, my lord. Approved 1,20,456. Midday meal availing 1 lakh.
See, let them chalk out some plan.
Yes.
If they can't, we know how to deal with that.
Well,
all right. In fact, we are slightly worried.
Well.
So if inquire from them,
well,
if they can find out, they will have to take a stand.
Yes.
That there is no or maybe minimum or minuscule this thing non-existent. Maybe something might have happened, but you can take this stand. But you cannot do it. You don't have any data. If you take this stand, then we will see what can be done.
Yes.
We may ask some other agency to do it.
I'll take instruction on that.
Otherwise,
Yes, ma'am.
Some outside agency to
Yes,
investigate.
I understand, ma'am.
You understand?
Well,
Some places they say children who have availed MDM is more than the PAV approved.
Yes.
That what is that?
We are not satisfied with the affidavit which has been filed by the director in elementary education in response to our order dated 14/7/2024 24, 14, no, it should not be 14, 7, 14. 14, 5. 14, 5.
14/5, 2024.
14/5.
Or 24, 6.
14/5, 2024.
14/5.
14, 5, 2024. So stop. List this matter on 3 weeks. Stop. Let the Director in Elementary Education ensure that an appropriate affidavit is filed disclosing clear pictures on the point of misappropriation of the amount of midday meal in the wake of the allegation that the said amount has been spent on in the name of such children who do not exist.
Non-existent children, non-existent.
List this matter on 4 weeks. For the said purpose.
3 or 4.
4 weeks. 4 weeks. 4 weeks. Contempt.
Specialist, content matters, CONTC 489 of 2013, item number 1.
We can take up other matters also if we are able to complete them.
Specialist, item number 1.
Yes.
Item 35 maybe tomorrow.
Yes.
Specialist, item number 1.
No appeals.
Item number 2.
1 to 5, Lordship, all are becoming purchase, Lordship. I am appearing all those matters, Lordship.
Item number 6.
It has become infructuous matter. No instructions.
Item number 7.
Heaven Lord's order has been complied with.
Complied with.
I filed a compliance affidavit now.
Item number 8.
The contempt proceeding stands dropped accordingly. Yes.
Item number 8.
It's also complied, your lordship.
Complied.
Item number 9.
9. Missing children.
No, it's by the, I filed the so-called affidavit. Para 5 and 6 also we can look at.
Item 9 of the last one, specialist.
9. Yes. Yes, sir.
I filed the complaint affidavit since long, Lordship.
No one appears on behalf of the petitioner. Compliance affidavit has been filed. The contempt proceeding stands dropped accordingly. Yes.
Supplemental list. Item number 35. Sir.
Dispute has suffered 3 rounds of litigation to this honorable court.
How round up?
3 rounds of litigation.
3 round.
And a very small dispute involved.
Yes.
So therefore, I have prepared a
small deck chart, my lord. Earlier I had given to your lordship.
Yes.
That what happened in this case on 16/12/2019, an advertisement was made for auction of 3 sand soils in Bonai Tahsil. That is Baliatota, Sandkori, Sabar Sandkori, and
Yes.
Sangagua Sandkori. And the minimum of price was fixed, the minimum additional charge was fixed.
What is your grievance?
The grievance is the opposite part number 5 had made the application in respect of 2 soils, and he was declared as highest bidder in respect of 2 soils, and it was finalized. One solvency was, he has deposited 1 solvency only. Though he was required to deposit 67,79,974 towards the solvency. He did not deposit. So therefore, the authority has no option to choose one in favor of that person when he was selected for 2 soils. So therefore, this honorable court, the appellate authority has passed the order, that is under Annexure 23. Appellate authority passed the order that there is no requirement for filing up two solvency, even though he was selected for 2 sand soils. This honorable court, your lordship, kindly see the order dated 21/6/2021. This honorable court specifically directed the government under paragraph 5 of the order. This court directs opposite part number 1 to 4 to inform the court what the correct factual position is, and in particular whether opposite part number 5 has in fact given up one of the sand soils, and if so, which one. And further, they will confirm if the calculation of the amount for which the solvency certificate had to be furnished as set out in paragraph 10 of the writ petition is
When
correct.
was this order passed?
This order was passed on 21/6/2021.
Then what happened?
Then the government filed the counter. Government filed the counter, and by way of an additional affidavit, government clarified he has not given up one, and he has given 1 solvency, and that is incorrect. That is not legal. The government affidavit, your lordship, kindly see.
Then what happened?
Then again, the counter affidavit was filed. He has not clarified in the counter affidavit. So therefore, again, this honorable court, my lord was a party to that order on 5/8/2021. Again, passed the order that you should specifically file the affidavit whether he has given up 1 soil. That affidavit was filed by the government, clarifying that he has not given up 1 soil. So therefore, the Tahsildar has no authority to choose 1 soil for one if he has selected for 2 soils on the basis of 1 solvency certificate. But that is my submission. Only this question involved. And
So who are you? What do you want?
that both the soils should be cancelled.
Right.
Both the soils, because he has chosen 2 soils, and he
Who are
was.
you?
I am the next bidder, and I was called upon to match the price, and I have matched the price, and thereafter I have deposited the amount, and thereafter the environmental clearance was given.
Let us hear.
My lord, in fact, my lord, for the 2 soirat, my lord, he has filed 1 solvency certificate for a sum of 40 lakhs. But for both the soirat, my lord, he has to submit 67 lakhs some odd. And the Tahsildar, what he did, my lord, Tahsildar has offered him in a 1 soirat, my lord, even if he has not withdrew the another soirat, my lord. The Tahsildar should have been reject the bid of the opposite partner filed, my lord, in both the soirat, that is the affidavit of the sub-collector, my lord.
So,
Pursuant to your lordship direction, I have
who is boss? Tahsildar or you? Or you sub-collector?
sub-collector is the appellate authority, my lord.
Appellate authority.
So then
Then
what did you do?
my lord,
Tahsildar did not act in accordance with law.
my lord,
Sub-collector corrected that
my lord,
in the appellate order.
my lord. No, in the appellate order, he has directed to grant the lease in favor of opposite partner number 5, my lord.
In 1 lease, Sahara and Quarry.
Sabara, my lord. That is under challenge by the petitioner, my lord. And by pursuant to your lordship order, Tahsildar submitted an additional affidavit.
No, that is under challenge by the, he has challenged the order.
My
of
lord, the petition
I
has
have
challenged this,
challenged.
appellate
I
order.
have challenged the next bidder,
Next, he is the second highest bidder, my lord.
second highest.
And he has already matched the price, the highest bidder.
What is the order of the collector?
Let the sub-collector order.
Sub-collector order is-
Answer
What is
23.
the order of the sub-collector?
To grant the lease in favor of opposite party number 5, my lord.
Opposite party number 5.
5, my lord.
He is L1. Sorry, he is H1.
He has quoted the highest bid, but his bid should have been rejected. My lord, he was the highest bidder. And he is the second highest bidder. Petitioner is the second highest bidder. And pursuant to order, petitioner the match the price and some time he had operated, my lord. Thereafter, the appellate authority cancelled his operation.
Why?
Because he said that the opposite party number 5 has quoted the highest rate.
So now you're praying that it should, both the thing should be set aside and fresh.
And since the bid has been finalized in my favor because I am the second bidder, I should be allowed to operate
4 years.
because I have
and
matched the price and I have also meet all the requirements.
Yes, what is your stand?
Yes,
Lordship, in fact, Lordship, sorry, Lordship, I am on VC.
can't hear you.
Lordship, I am in virtual mode, Lordship. Lordship, can allow me to place the case, Lordship. In fact, my Lord and Senior has argued this matter and had taken grounds that I have not filed, Lordship, proper solvency certificate as per requirement under law. Lordship, that part I will answer. Prior to that, I want to, Lordship, appraise Lordship. Lordship, kindly see this tender, this action notice of 16/12/2019, Lordship. By the annexure 1, my Lord and Senior is annexed to his deed application. Lordship, here 16/12/2019 is the Lordship date of the action. And Lordship, kindly come to annexure 2. Just one day after, Lordship, the competent authority came up with, Lordship, the details of the sand quarries, Lordship, which is to be put to action. And I had participated in 2 Lordship action, that is serial number 2 and 3. Along with the petitioner, I had participated in both the Lordship sand quarries. And in both the sand quarries, I had been declared the highest bidder, Lordship. Lordship, kindly see for a moment for the provision of the rules, Lordship, for 27, Lordship, for kindly moment. Just these 2 points I am arguing on the ground of maintainability, then I will come up the Lordship merits of the case. What the point my Lord and Senior asked, Lordship. Lordship, kindly come to rule 27 for a moment. Lordship, what is it?
Blacklisting. Under
Plus 27, I am reading, Lordship, 27, Lordship, first, Lordship, I am reading the.
So we want to know whether whether there is any provision for blacklisting
No, Lordship.
under the rules. No. So
Under the rules, there, Lordship, there is provisions for cancellation, but there is no provision of blacklisting, Lordship.
all right. That will
Lordship,
have,
kindly come to, Lordship, kindly come to rule
that
4.
provision will have to be incorporated under the rules before someone is blacklisted.
Lordship, that is not available under the rules, Lordship.
All right.
But Lordship, kindly come to 27 for a moment, Lordship.
Yes, we are there.
Lordship, 27, Lordship, clause 4 speaks of, Lordship, the
Yes.
procedure, how to participate in the Lordship tender procedure, auction procedure.
So where are reading?
Lordship, 27, Lordship, sub-rule, 27, rule 4, Lordship.
Yes.
No, it's not there.
Subject, Lordship,
No.
Page 44. Let us continue, so now.
Yes, subject to other provisions.
Lordship. Subject to other provisions of their rules for settlement of quarry lease in the intending applicant may apply to the competent authority in a sealed cover for grant of quarry lease for such area or areas in form M triplicate accompanied by the following documents in particulars, namely treasury challenge showing deposit of 1,000 rupees refundable towards an application fee. Second, Lordship, an affidavit stating there are no mining due payable under the Act and the rules made thereunder is outstanding against the applicant. 3,
proof of payment of earnest money equivalent to 5% of the minimum amount additional charges specified in the notice, in the amount of royalty both calculated on the basis of minimum guaranteed quantity for 1 whole year for the minimum guaranteed quantity for minor mineral to be extracted in 1 full year. And 4 is important for the present context, Lordship. A solvency certificate or bank guarantee valid for a period of 18 months.
Where did it?
Lordship, 27, 4, then Roman 4, Lordship. Roman 4 is the present subject matter of the writ application, Lordship. Roman 4. 27, 4, Roman 4, Lordship. Odisha minor mineral constitution 2016, Lordship, I am relying. The Odisha minor minerals concession rules 2016.
No, I am handy. 27-4.
Rule 27,
4, Roman 4.
4 reading, Lordship.
Why is this different?
Chapter 4, grant of query lease.
All right, yes, then.
Then Lordship, Roman 4, I am reading. Roman 4, Lordship, reading.
Yes.
A solvency certificate of or bank guarantee valid for a period of 18 months for an amount not less than the amount of additional charge offered and the royalty payable for the minimum guaranteed quantity for 1 whole year and a list of immovable properties from the revenue authority. So this is the requirement under law, Lordship. So it is very clear, Lordship, a valid period 18 months, amount not less than amount additional charge offered. So there is a qualification, Lordship. The amount offered by the competent authority, I have to deposit the amount as per the additional amount referred to the Lordship, the auction notice. The Lordship kindly come to Annexure 2 for a moment of the interpretation.
Yes.
Lordship, as per Annexure 2, as per the specification, I have deposited the entire additional amount, Lordship, as per the auction specification. But now they are coming up with, Lordship, with a plea that what amount I have quoted. Lordship, I have not deposited that amount. That is not a fact. That is not the never the legislative intention while coming up with these rules. Your Lordship, for a moment to clarify, Lordship, please again, Lordship, kindly come to Lordship, Rule 27 once again.
Additional charge offered. Additional charge is fixed, my lord.
Please,
and it will vary from person to person more than that.
Please don't worry. I am clarifying to Lordship. Please don't. Lordship, kindly, the amount is, they have quoted 2, they have used 2 words, Lordship. One is offered, one is quoted. So this is the difference between the statutory language, Lordship. Rule 27, Roman 4, it says, Lordship, an amount.
Yes, you don't have to repeat that.
Lordship, then
understood.
Lordship, kindly come to Roman 4, 5, then Lordship. 5, Roman.
5.
5, Lordship, then 5, Lordship.
Yes.
Subject to the provisions of the rules, the query lease shall be granted in favor of the applicant who has quoted the highest rate of additional charge. So, Lordship, this is the consideration to consider the highest bidder who has quoted the highest price. Then Lordship, kindly come to Lordship, rules, then 7, Lordship, chapter 7. Within 15 days of the search intimation.
Mr. Counsel, did you submit this solvency certificate?
Yes, Lordship. That is in accordance with the provision of law, Lordship. I have deposited the entire amount.
Solvency certificate you had applied for 3 queries.
2
queries.
2 mile.
2 queries, Lordship.
You had given 1 solvency certificate. Did it cover the value? Did it cover the value for both the bids?
Yes, Lordship. That is my entire submission. It covers both the bids, Lordship.
How?
It covers. That's I'm clarifying, Lordship. Perhaps because that has been clarified by the appellate authority in his appellate order, Lordship. But here, the advocate appearing for the state is relying a clarification by the issued by the other officers. But Lordship, kindly come to page 23, Annexure 23, the order of appellate authority which is under challenge. It speaks of the entire Lordship, volume of the case, Lordship.
Yes, page.
Page 140, Lordship.
140, yes.
140 of the writ application. Lordship, can you come to page 143 for a moment, Lordship?
140?
43, Lordship, in detail, but I am relaying, Lordship, the relevant person, page 143, Lordship, can you come? Lordship, I am reading, Lordship, fourth paragraph. It is seen from the case record, Lordship, but page 143. It is seen from the case record. Lordship, Lordship, got it, Lordship, can read it? It is seen from the case record that the appellant had quoted the highest additional charges and having fulfilled other essential
What is that?
requisites had been selected.
Fulfill other essential requisites.
Requisites, Lordship.
Yes.
Requisites had been selected as the highest bidder. And accordingly, for F was issued by letter number 109 dated 16/1/20 by the competent authority. Such selection of the appellant as the highest bidder was not questioned before the appellate court by any of the unsuccessful applicants in respect of Savara Sandbag. This court also finds no illegality in declaring the appellant as the highest bidder in respect of the said Savara source by the competent authority. On specific query by this court, the advocate for the respondent 2 categorically stated that no appeal is preferred by the respondent 2 challenging the selection of the appellant as the highest bidder. This court also finds the respondent number 2 was the second highest bidder applicant in the said tender with for the Savara Sandbag on 28/1/20. The unsuccessful applicant, that is respondent 2, filed a petition before the competent authority alleging that there was illegality in the selection process as the appellant was selected having furnished one solvent certificate for 2 bids and the appellant was
We will hear you tomorrow.
Lordship, day after tomorrow, Lordship, grateful, Lordship, grateful.
Yes, sir. Tomorrow.
Lordship, can it be 2 o'clock, Lordship, so that it can be this, cannot?
Some mention was being made in the morning. London Council, huh? 52. 52, who is there in 52? Yes, madam? 52. Why is the matter so urgent?
No, my lord, the counseling procedure is going to be start soon, so there is no
Counseling
mine.
of
JEE main examination.
JEE main examination.
Mine.
What can be done now? You will have to wait.
Tomorrow on the top of the list, whatever there is.
No, what has happened, you tell us.
My lord, that is the matter pending for the taking instruction from the JEE main authority. The additional solicitor general is the opposite party.
Yes, Mr. Padi?
All right, tomorrow I will take up. Tomorrow we will prosecute cases.
Our first 5 cases, all right?
Mine.
Thursday.
Thursday, sorry.
Okay.
Yes, any other urgent matter?
I beg pardon to mention a matter, my lord. Today's list, item number 55. Matter will be taken on Thursday, my lord. On top of the list, my lord.
Oh, no, not top of it. Why?
My lord, it's a tender matter and we are the successful technical bidder, my lord. Due to the pendency of the rate application, our financial bid has not been opened. It is pending, my
You are
lord.
the respondent.
Yes, my lord. I filed an interim application for intervener.
But there is no interim order passed.
The appellate authority has stopped the same because the irregularity has committed by the tender inviting of the competent authority. The lordship yesterday the matter was there. The lordship was posted to today for hearing. Lordship called in Thursday.
Thursday, top of the list, my lord.
Top of the list.
Same perspective.
Grateful, ma'am.
Can I pray item 43, my lord? Can it be taken up on Thursday, my lord? Since,
All the matters are taken.
yes, grateful, my
Take item, my lord, back on next week, my lord, 38. 38, to day after tomorrow, I will not be there.
38 days.
or first week of August, my lord. What's up?
38 is again a batch of matters.
Yes, my lord.
State is the
In that case, interim order to
State is
continue.
the appellant.
In that case, interim order to.
State is the appellant.
Interim order in all the cases, all the
Yes,
cases.
This is all the cases.